Yes.
May I, Dr. Kind indulgence to move these three petitions on Monday, my lord.
Why?
The IOCL authorities, my lord, have issued so cause notices in violation of the MORTH guidelines, my lord. They alleges that the trucks we have applying, my lord, the manufacturer is not the Tata Motors, that's his manufacturer, my lord. But Vahan shows the manufacturer name is Tata Motors. And in the meantime, they have issued the NIT.
Okay, Monday you have filed it.
Yes, ma'am. Yesterday we have filed.
Then it will obviously come. It won't come.
My lord, I have included additionally, my lord, they told me to make a mention before rock statement for Monday.
Okay, Monday.
I am deeply of them.
With due permission, Lordship, this matter is supposed to be listed today, Lordship, but it is not listed today, Lordship. Tender matter, Lordship. We have to submit the results in a seal cover, Lordship. We have to submit the results in a seal cover. It was directed to be listed today. So maybe taken up on Monday, Lordship.
We'll take it up today if it was directed to be listed. Give it to him. We'll take it up today. Give the other side.
Lordship, I am for the respondent, Lordship.
Petitioner?
Petitioner, Mr. R.J. Das. Mr. R.J. Das.
R.
J. Das.
Inform him.
Lord,
It was fixed today, na?
it was fixed today, Lordship.
Come today.
Yesterday also the mention being allowed. So yesterday was being made and it was allowed to be listed today. But the matter is not being listed. It is listed on Monday. There was urgency in the matter.
What is the matter about?
The matter is about the students of LLB. Your Lordship, their 10th semester exam has been result has been withheld, saying that they have used unfair means. Thereby, they have their AIB examination by 30th of this November, and they are not being able to sit for the examination if they are not being allowed.
13th of November.
30.
November is 30, 30. Time is there. Monday is okay. What is Monday? 24th. No problem.
But the registration process has already been stopped, has been closed. So there is a very clear process.
If it is closed today.
We not say we have to mention before the bench two. Bench two.
Bench 2. Bench 2.
Yesterday, Your Lordship has allowed.
First of all, the lady who mentioned this matter, she was not very clear what she did, isn't it? I remember there was a mention being made. But if the matter doesn't belong to this bench, obviously that is why.
Bench 4.
Bench two academic matters bench two.
Huh?
Academic institution examination all are bench two. Academic matters.
So it is for some AIB.
Yes, they have their 10th examination result.
Who is not permitting you to appear?
Wadi University.
Then bench 2. Not this.
All right.
May it please your lordship, I beg to mention item number 20. My lord, can it be updated, my lord? I have a flight at 1:15, if it can be updated.
Item number?
20, my lord.
Okay, we'll dig it up. Immediately, you have a flight at what time?
1:15 PM today.
Who is there for IPDCL? He's there.
Yes, my lord, I have taken the consent.
Okay, we'll take it as the first item.
Much obliged.
I beg to mention the WPC for this thing also.
What?
WPC,
For?
this thing,
Okay. When?
25 Your Lordship.
Motion?
25 November.
Motion?
Yes, admission.
Admission. What is the urgency that it should be on 25th?
Your Lordship, since last 5 years, Your Lordship, the health department have they took rent. Health department took rent of our house, Your Lordship, and they have
What?
paid the rent. Health department, they took the rent of our house, Your Lordship.
They have?
They took rent.
They have taken on rent the house. Then?
They have not paid any fees, Your Lordship.
So what is the urgency?
This 5 years, I've done this.
When did you file the writ petition?
It was on 1990.
2025. So there is no urgency. Absolutely no. We will get the rent when it is due, 1st of December. Not before it. Yes. Next. Or what? Withdrawal? Monday? Withdrawal. Okay, let us take his matter. Item number 20. He has also.
My lords, I have advised
That
the
too,
department to.
His matter pertains to those two clauses.
They have
MSC.
taken a decision to otherwise cancel the tender process. I've just advised them to withhold the final order because this matter was pending, Your Lordship, before Your Lordship.
So you are cancelling. So nothing is. Heard Mr. D. Rathi, the learned counsel, appearing on behalf of the petitioner, and Mr. K. P. Pathak, the learned standing counsel of the APDCL. Full stop. The petitioner herein have challenged the decision of the respondent authorities in not granting the benefit of EMD exemption to the petitioner. Which is petitioner, though the petitioner is an enterprise falling within the ambit of the MSME Act 2006 and is further mandated as per the tender conditions. Mr. K.P. Pathak, the learned counsel, standing counsel submits that taking into account there being various discrepancies in the bid security of the EMD clause in the bid document published by the NIT dated 3/11/2025. The respondent authority have already initiated steps for cancellation of the tender process and to issue a fresh NIT. The said instructions, so an instruction in that regard dated 19/11/2025 have been placed before this court, which is kept on record and marked with the letter X. Taking into account that the respondents are taking steps for cancellation of the notice inviting tender dated 3/11/2025 and a fresh notice inviting tender would be issued, nothing further remains in the instant writ petition. Accordingly, the writ petition stands closed.
My lord, the NIT date is 4/11.
4/11.
4/11. Deeply obliged.
Lord, motion item one.
My lord,
What is this?
the norm, direction is my lord, 15 para 7, my lord.
Tamsir Ali.
Page 15 para 7. Non-payment of contractual amount.
PHE. When did you inform?
My lord, para,
29/7/2024.
yes, my lord.
And you informed 4/8/2001. Now tell me, Mr. Counsel, how these directions can be complied with? Give me a good idea how it can be complied. On one hand, it is said that you carry out a verification, isn't it? Secondly, it says, do as per Tamsir Ali, isn't it? And thirdly, most pertinent, do everything within 3 months. Is it possible? What is Tamsir Ali? What does Tamsir Ali say? You have not read a brief.
Lord.
What does Tamser Ali say?
They have, let them verify and examine, my lord. If admitted, my lord, that the amount.
Now,
then
is it
came
your
to-
case that they have not verified?
No,
Or is it your case that payment has not been made?
Payment is not paid, my lord. I have instructed, my lord, they have already verified, my lord.
So have they put you in the chronological list? That is the most pertinent thing. If they have put you in the chronological list, then Tamsir Ali is followed. But if they have not put you in the chronological list, then Tamsir Ali is violated. Because if the court directs, because in PHC, in my opinion, Tamsir Ali is not applicable. So the question is, if the payment is to be made, then the payment is to be made within 3 months, if it is verified. Which department is this?
PAC, my lord.
PHE. You wait for some time. And why you are making everybody a party?
Lord,
Who
actually,
is to pay?
Respondent number 2, my lord.
Two. Why you are making everybody a party?
Public and engineering department.
What is the member secretary going to do, or the district commissioner going to do? Executive engineer, what are they going to do?
They verified, my lord, at the time of filing this petition, my lord. So I made it possible.
And where is your document which have been issued to those persons? Where are those that you have served upon these persons? There's nothing out there.
Page 16, my lord.
What is page
Member
16?
Secretary.
Yes, this is a document.
Rongia Division, my lord.
Understood. It is only being given to the Rongia Executive Engineer PhD.
Yes.
Where are the other receipts? Copy to the Principal Secretary, Chief Engineer, all these things. Where are those receipts?
My lord, I have documents, my lord. I
Huh?
produce documents up
What?
if necessary, my lord.
Where have you given it to the Secretary?
I have already served, my lord.
The Chief Engineer? No, you have very well served, but the question is, how do I know? Isn't it required to show that you have served?
I have permitted to additional affidavit.
Ah. The counsel appearing on behalf of the petitioner submits that he would like to file an additional affidavit showing that all the respondents herein who have been arraigned have been duly served the certified copy of the order dated 29/7/2024, passed in WPC number 1811/2022. Full stop. List the matter next week. How much time?
First week of December.
Okay, list the matter on 3rd of December 2025. So, yes.
Yes, madam. This for instruction.
No instruction. First tell me what is your case? What are you challenging?
Challenging the improved selection,
Huh?
selection process of Mohalla
Of
for the markets of the
Market.
and monthly markets of Kendu.
election process and consequent list conducted and prepared for selection of the private responder as Mohaldar for Kendukona daily and weekly market. Okay. Now what has happened?
My lord,
Notice inviting tender was issued.
para number 8 and
No, what is your case? It has been given to the respond number 9.
yes, madam. So respondent number,
What is your allegation that he should not get it? Why?
yes, madam.
Where is the order? Impugn order.
Immune order is not available, only on my submission before the Honorable Court. The Chief Executive Officer, Kamrup Jilla Purikhot, the respondent number 3 herein, he has issued 2 orders directing the GP Secretary of Kendugona Hara to comply the orders, but GP Secretary has not complied the order passed by the Chief Executive Officer, Kamrup Jilla Purikhot, and hence I approve this Honorable Court for directing the DP secretaries to comply their orders.
So your case is that you are the highest bidder,
Yes,
but is it, but why are you saying that there is some selection to give it to respond number 9?
already he has been given.
Where is that order?
Order, we made an application under RTI Act, seeking the proposal for selection of the Mahalda, but that has not been given us. So
Okay.
we are unable to annex the same deputation of my lord.
Okay, yes.
My lord, I'm praying for a short accommodation, my lord.
Why?
My lord, I have not received a proper instruction, my lord. There's
Oh.
next week, any date, my lord.
The matter may be fixed Monday, my lord.
Huh?
Monday, already available. time
Monday
is
already government holiday is there, my lord. For state holiday is there, I think, my lord.
Why?
One
Something
week
is
has
there
been
on Monday, state holiday is there. High court is not closed. my lord.
24th is
On
state
Wednesday.
holiday.
Yes.
Yeah.
Matter may fixed on Wednesday, man.
First of all, I'll issue notice.
Yes,
Without issuing notice, I don't disturb the state government.
man.
Now, it is you have stated that it has been now given to the respond number 9.
9.
Where is your statement? Where is your statement in your writ petition?
My lord, but yes, my lord. I'm sorry, my lord. I am to read out.
Huh?
Yes, my lord, para number 7. That the petitioner father stated that after coming to know about the selection of Soyad Manik Ahmed, initially Manik Ahmed was selected as Mahalda for the Kenduna daily and weekly markets. They collected records of criminal case, PRC case number 481/2025, pending against the selected candidate Soyad Manik Ahmed in the Honorable Court of Justice Rongya Kamrup, a copy of which has been submitted before the Kenduna Haraka Concert Authority, respondent number 7 and 8. On receipt of the records of criminal case, the Kenduna Haraka Concert Authority, that is 7 and 8 respondent, has subsequently reselected on Babu Ahmed, son of Yunus Rahman, illegally and unconstitutionally without cancelling the selected candidate Soyad Manik Ahmed, that too, who was selected in serial number 4 in the select list. The selection of Babu Ahmed is totally illegal and unconstitutional because he is the lowest rate of bid, rupees 1,09,999. Then that of Mintu Ali and Minal Ali.
You are Mintu Ali.
Yes, my lord.
Maybe, my lord, because of, my lord, item, the clause 19, the earlier selected candidate was rejected, maybe, my lord. The clause 19 is saying, my lord, is page 19. The
Involved
tenders
in any kind of violent activities, torture,
that's-
exploitation. Now, you are espousing the case of this person, Manik Ahmed.
Manik Ahmed. Manik Ahmed initially selected and video clip was done, but that has not been available because we are unable to furnish those copies, my lord. But as per information given by the petitioner's concern, Manik Ahmed initially selected. Well, a criminal case has been pending and record has been placed before.
So he was removed.
Yes.
Now it is being given to the respond number
Number
9.
9. Babu Ahmed.
Although respond number 9 is bid is lower than yours.
Yes.
That's your case.
Yes. And already CU, Chief Executive Officer, has also passed an order.
Huh?
In Excel.
Okay, okay. Don't worry. We'll take care of it. Issue notice making it returnable on 1st of December 2025.
Second December maybe, because I have a sessions case on 1st December, madam. Second December maybe.
3rd of December 2025. Mr. S. Dutta accepts notice on behalf of the respondent number 1,
1,
3, 4,
1, 3, 6,
no, 4?
4, my lord, chairman, I cannot appear, man.
You can, all these things don't come out. 4,
6,
6, 7,
then
8.
Yes.
Full stop. Mr. K. Gogoi, the learned additional senior government advocate, accepts notice on behalf of the respondent number 2 and 5. Extra copies of the writ petition be served upon them during the course of the day.
My lord, before Monday.
During the course of the day.
Okay.
Okay, we can have it on 10th of December, Monday.
No,
Third,
no, my lord, I shall try to give today.
during the course of the day. As regards the respondent number 9, the petitioner is directed to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that pursuant to a notice inviting tender issued by the who has issued? Who has issued this tender? Secretary.
Yes.
Secretary Kendukona Harara
Hahar.
Gaon Panchayat for settlement of the Kendukona weekly market and Kendukona daily market. The petitioner and various other bidders participated in the said bid process. Full stop. The petitioner's bid in respect to the Kendukona daily market was rupees 1,10,000, whereas the bid of the respondent number 9 is rupees 1,09,999, 1 rupee. In respect to the Kendukona weekly market, the petitioner bid how many petitioners are here?
Two petitions, my lord.
Absolutely, you cannot file this type of writ petition. How can everybody is having conflicting interest? So it's a cartel. We dismiss your ground on that. No, we dismiss it right away. Lekhok, heard Mr. So-and-so, no notice. Heard Mr. So-and-so, the learned counsel appearing on behalf, you withdraw and file separately, both.
My lord.
Withdraw, you can't come up late. Because in both the cases,
Separate.
this Mintu Ali and Minan Ali has been tenderers. In one case, Mintu Ali is the highest. In the second case, Mintu Ali is the second highest. Minan Ali happens to be, in the first case, second highest, and he is the highest in the other one. So there is not conflict of interest. How are you taking up both their matters?
My lord, I may be permitted to.
Withdraw.
Withdraw and withdraw.
Withdraw. The counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant writ petition, and liberty may be given to the petitioners to individually espouse their cause of action. Full stop. Taking into account the above, the writ petition stands closed on withdrawal. Full stop. The petitioners, both the petitioners are given liberty to file separate writ petition if so advised.
Item 3.
Mr. Datta, you point out these things. The
Well,
moment I
actually-
saw it, that is why I am shocked to see. Yes, again another site visit. You and your site visit, let me now scrutinize it very properly. Wait. Your site visit cannot happen like this. Where is the site visit thing?
Yes, you want,
Where is that certificate? Same order.
yes, my lord.
Where is Mr. B. Gogoi? We even need not look into all these things.
Same order, madam. Yes, tomorrow's order, madam.
Yes, yesterday's order, not tomorrow.
Yesterday, right?
Yes. Yesterday order, we passed the same order.
Yeah.
Same order and fixing it on the same day. You just get your instruction and same order. Itu agor order to. This is package.
There are three more matters, my lord. Let it be listed on Monday. Otherwise, one is coming up, my lord, same tender, my lord.
My lord, we file same day, my lord. I don't
Okay, you do one thing.
Serial number maybe.
No. You have got the mention. Have you mentioned it?
know, my lord.
Have you filed it or not?
File.
Okay, make a mention memo, give it, we'll take it up at 2 and finish it off.
My lord.
Yes, yes.
Those matters.
Fine.
Give a mention memo, give it, all these matters. This is package number
Package number 6, my lord.
6?
My lord.
Okay, 6 or the silo, huh?
My lord.
Item 4. You give a mention memo.
My lord.
Forfeit. Non-payment. Like Mr. S. Hawk does matters of site visit. He does matters of all the police non-payment, isn't it? এই non-payment করে দিব, date হল 10th of February 2000 year, filing affidavit by 30th of by 4th of February. এইখন ভুল হৈছে. By 9th of February and filing affidavit by 2nd of
5 and 6 also similar. 5 and 6 also similar.
10th February, huh? 10th, oh 9th. এইখন আকৌ এইখন আহি গৈছে ন, দুইটা কনফিউজ হৈ যাওঁ. January হলে এইখন 2026. 9th February and filing affidavit by 2nd. What is this?
My lord,
Devoter.
But there is a reference been made against the petitioner, and she appeared before the tribunal, and she submitted that although her name and her husband's name are similar and her residence address is also similar, but her father's name are different, and they requested the foreigners tribunal to conduct a police inquiry as regard the same. In one case, the police gave a report that both the fathers are different. Then accordingly, the foreigners tribunal discharged one of the person whose name is Fazila Khatun, but again, similar Fazila Khatun, wife of the similar person, has been declared as a foreigner. The opinion is, in page number 40, Annex 11, Lordship.
So has that been challenged?
No, Lordship.
You have to challenge that opinion if you are do you come within it?
Father's name is different. Therefore, I was discharged from the proceeding.
The husband is same.
Husband came, Lordship.
Maybe same.
Why you are going into
Same.
the
Person is different.
Huh?
Person is, father's name is different.
So how many fathers have the same name in the same locality? With the husband's name being same? The
At least the-
coincidence seems to be very difficult. So much of coincidence.
Research says that the police has submitted report that the father's name is different, person is different. Therefore, he has been discharged. He has been discharged from the proceeding.
Okay, issue notice. Notice you file it. Issue notice returnable by. But this is not a challenge to that award. You
No,
want the
they have not-
removal of the D.
They
So,
given a
madam,
representation before the ERO,
Authority
Lordship.
may verify again.
Election,
And
election
if
of-
he is suspected, then suspect is remain, then new proceeding may be done against her.
They have,
Hmm?
they filed a representation before the election officer. But in the entire representation, there is no mention about the opinion that has been passed or they have participated in the opinion. So it becomes difficult to remove the Lordship.
Why you have not mentioned all these things there?
No, we have.
You have come for this, before
We
this
have-
court for the first
we have-
time. Where is the represent,
Received a notice.
Mr. Sikdar, where is your representation?
Ace 44, Lordship.
The D has been marked against my name in the voters list without hearing me, without spot verification and without giving an opportunity to demonstrate that I am not a foreigner in Toronto. That's why my parents were in the voters list. Hence my name. And I have voted in 69, 66, 70. So you, your parent, where do you who stay?
My parents.
In the same village?
My lord, village is,
Your village is different
my village is, Duguchor.
and your father's village?
Other village, the voter list,
Buduchor.
Buduchor.
And your village is Dubusor.
That may be wrongly
Opinion,
written.
it is written, your lordship, Kundorpur village.
Huh?
In the opinion that has been rendered where she appeared, because notice was served, she received a notice, lordship, in page number 40. Here,
Page number 40.
40, lordship. And it's Ila Begum, daughter of Dabur Ali, wife of Sarves Ali, village Sundorpur, PS Motia Gwalpal.
Notice was served on me. We received the notice, I appear and stated before the tribunal that my father's name is different. My father's name is not Jambur Ali. Notice indicated, notice indicated that father's name is Jambur Ali, but my father's name is different. My father's name is uh, my father's name is Faizuddin Ahmed. Therefore, the tribunal or after receiving the report from the police, my name is discharged from the proceeding. My grievance is even after this order, there has been demark against my name in the voter list of 2022, 2024 also.
Yes. So here, whatever may be, rightly or wrongly, it has been held that this particular petitioner, whose father name is so and so, is no, there's no case pending against her, has been discharged.
Lord, she has claimed
And
that-
accordingly, notice has been directed to be issued upon so and so.
Look.
Then you have put that name up into the 2022. It is their case that this opinion was rendered in the year 2019. In 2022, you have done it. Why you have done it? I think you should reply to that.
Lordship, because in the 2011 voter list that they had annexed, Lordship, there is some cross marking over her name. So I will verify whether it has been marked in 2011 itself, Lordship. It is in page 32. Because the second petition also, the similar case, Lordship, it has been marked in 2011 itself. In page 32, serial number 2, Lordship, Fazila Khatun. So Lordship, serial number 742, there is little bit marking. So I will just verify whether in 2011 she has been marked D or in 2022.
2000?
11, Lordship, in page number 32 of the report.
Here,
What is the name of the petitioner?
Fazila Khatun.
here D mark is not there.
I'll verify, Lordship.
Serial number?
742.
And my village name is correctly mentioned here, Buduchor.
And what is your father, your name? Sorbek Ali.
Yes, husband's name. This
And
village name is correctly mentioned Buduchor. This is my voter list. I am 2011. I am not the voter. Then 2022 after.
and what about 2015? What about 15?
15 voter list I have not next
Why haven't you enclosed?
that
Why haven't you enclosed? This is relevant. Then otherwise, why I am saying it is relevant, 2015 voters list is relevant because your reference happened in the year 2019. Reference happened in the year 2000.
it was 2003. I am the
IMDT 2003. So why your name was not shown against the voters list when your name, that person's name was there? Because that was the director in Mameza Khatun. So your case was pending. Why the de-voter has been made later on? What about your 97 voters list? 97?
97 brutalist,
Because the 97 is the most important because you are in IMDT.
I am not,
This was an IMDT case, IMDT case, reference case number
Place, page
28 oblique 2003.
page 30, my lord, 97 brutalist. My name is there at serial number 556,
Where?
page 30, 30,
97.
97 brutalist.
97, she is not on larger team.
97.
It starts from page 29. also.
And where is your father's voters list?
Others brutalist,
Not.
Lordship will find at page 19. Faizuddin Ahmed, page 19. Khanakular at page 20.
This is 66. And where does your father remain, reside now?
In the same village, Buduchar,
Is he alive?
that I have no instruction, my lord. I need it. Father. No, father is no more, my lord.
Lordship, lady records of this particular case may become.
Hmm?
Records may be called for Lordship of this.
No, we'll issue notice. This is the case where notice is issued. Issue notice making it returnable on 15th of December 2025. Home,
Yes, sir.
you are paying for home.
I'm two.
Respond number 1,
2 and 7, Lordship.
who is paying for whom? You. Mr. K. Gogoi accepts notice on behalf of the respond number 1.
1 and
Mr. You appear for respond number 2,
2 and 7, Lordship.
2 and 7. Okay, Mr. I. Ali appears on behalf of
3 and 5.
3, 4, and 5.
4 the Lordship, State Election Commission, Punjab.
Why are you making the state election commissioner a party?
Well, it may be stock of my.
I can't strike off. 3, 4, and 3.
And 5.
Okay. Very good. Wait. You have made the unnecessary party, so we make it. 3 and 5. 6. Who appears? You, Mr. Bugole, appears for respond number 6. As regards the respond number 4, the extra copies of the writ petition be served upon the learned counsels appearing on behalf of the respondents, representing respondents, represented respondents by tomorrow. As regards the respondent number 4, steps be taken by way of speed post by tomorrow. In addition to that, petitioner is also directed to take steps by Dusty upon the respondent number 4, routed to the registry of this court and file an affidavit of service on or before the next date. Full stop. The case of the petitioner herein is that the petitioner name the petitioner's parents' name were in the voters list of 1966, 1970, and 1979. Full stop. The petitioner's name was inserted in the voters list in the year 1985.
89 also. 89, 97.
What?
89, 97 also.
85.
89.
85.
85 also. 89,
85, 89,
97.
97.
2011.
Full stop. Uh, 2005 and 2011. Along with her husband, Mohammad Sarbes Ali of village Buduchor. Full stop. It is the case of the petitioner that in the year 2022, the petitioner name was a D has been marked against the petitioner's name. And as such, the petitioner has therefore approached this court. But if D is being marked, how can the foreigners tribunal will look into it?
Lord, sir, matter may be, we are pertaining to division bench, Lord, sir.
No. This has to be looked by the foreigners tribunal.
Lord, sir.
So we asked them to make a reference because here this reference has said that he is not there.
He is not.
So if the petitioner is a D voter,
Reference has to be.
so reference if not made to be made.
Do matter, Lord, sir.
I think that is the best
Yes,
option.
Lord, sir, that will be.
Yes, my lord. My lord, I am ready.
Issue notice
them
হয়
verify?
এইটো এইখিনি কাটি লৈ এইবোৰ হিয়াৰিং কৰিলো তাৰপিছত এই আগৰখিনি এইখিনি লিখিলি তাৰপিছত এই লাষ্ট পেৰাগ্ৰাফ খিনি দিলি 2022 the petitioner the case of the petitioner further is that earlier in a proceeding being FT case number 5/1312/MA/19 which was in connection with IMDT reference case number 228/2003. The petitioner was issued a notice. However, when it was pointed out that the petitioner is the daughter of
Faizuddin.
late Faizuddin and not the daughter of late Jambur Ali, the Learned Foreigners Tribunal number 5 at Gwalpara, by an opinion dated 16/12/2019, had discharged the petitioner. It is the further case of the petitioner that in spite of that, the petitioner's name have again been put as a D voter, has been marked against the petitioner's name, a D has been marked. And as such, the petitioner has approached this court. তাৰপিছত paragraph 4, 4, 5, 6, 7, 8. Disposed.
Item 9 is also lot of similar. Item 9 is also similar.
Same. Again, wrong father's name.
India, the police give a report that both the father name are similar person. Lord. But
Is this
still
the
the foreigners-
husband?
Husbands are same. Husband name is correct.
No. Here, father's name is, in the proceeding is Mehadus Ali, but father's name, he claimed that, her father's name is different.
Miyaruddin.
Miyaruddin.
Here also reference.
appeared.
Charge.
Discharge,
Lord.
And which is the SP?
Gwalpara.
Gwalpara.
আৰু এইটো চাই দিব হা এটা legislative assembly সেইটো নম্বৰটো লিখিল Yes, what is this? Mr. Sharma, what is your case?
May I please, your lordship. My lord,
Appellants prepared an appeal before the honorable with a prayer for condonation. The petitioner challenged the order here will delay. Meanwhile, the petitioner as well as plaintiff have Yes, what is wrong with the order?
Lordships, I preferred the appeal before the Honorable Assam Board of Review, Lordship, accompanied by a petition for condonation of delay, Lordship. The delay petition is rejected, Lordships. Against that, Lordships, I have approached before this Honorable Court, Lordship. Lordship, this, I have shown the grounds, Lordships, sufficient cause, Lordship, in my application, Lordship. And in spite of that, that application is rejected, Lordship. Lordships,
What have you challenged, Mr. Sharma?
Lordship, this order was passed by the additional deputy commissioner, Lordships. Against that, Lordship, I have preferred the appeal, Lordships.
After 1138 days.
After 1,138 days, Lordship. Lordship, in the meantime, Lordship, this petitioner filed a title suit, Lordship. So as title suit was pending, Lordships, because of that, Lordship, they did not prefer the appeal, Lordship. When the title suit was dismissed, and further they have not preferred the appeal, Lordships, against the dismissal order of title suit, then they have preferred the appeal, Lordship.
What are you challenging in this order? In the appeal, what are you challenging?
That order which is passed,
By ADC, what order was passed by the ADC?
Lordship, that order, it is against me, Lordship.
Where is the ADC's order? But you should have taken the leave out there under section 14. Why didn't you take
Lordships,
from the trial court? You should have said that as you are dismissing on the ground of limited, on the ground that there is an alternative remedy or the court does not have the power. The civil court's jurisdiction is not there. So you give us the benefit under section 14. Then only you could have got that bona fidely. I can't decide whether it is bona fide or not. Neither the Board of Revenue can also decide the bona fide. The bona fide has to be decided by the court which passed that order.
Lordship, now the question has come regarding condonation of delay, Lordship. That condonation of delay, that has not been considered, Lordship. Lordship, I have a citation, Lordship.
Bad case. But Mr. Sharma, tell me one thing. Like in an appeal, you file a suit, decree is passed, you file a delayed appeal. Your condonation application that's dismissed. Against that, you can file a second appeal. And in the second appeal, you have to have substantial question of law as insofar as the decree which has been passed by the learned trial court. That's the principle. Because what happens when it is dismissed, it amounts to a confirmation by the Assam Board of Revenue, the order passed by the ADC. Against that, can't you come therefore by way of a writ petition challenging the ADC's order? I'm asking you.
Lordship, yes, I have not preferred the appeal against the title suit, Lordships.
No, I'm not on title suit. ADC passed an order.
Passed the order,
Against that, you filed an appeal before the Assam Board of Revenue.
Lordships.
Assam Board of Revenue dismisses it on the ground of delay.
Delay,
So the moment it is dismissed on the ground of delay, doesn't it amount to confirming the order of the ADC by the Assam Board of Revenue?
Lord.
Thereby you can very well challenge the ADC's order here. As it is a confirmation by the Assam Board of Revenue. Don't you think so? So this court can very well take up that issue.
Now, Lordship, at this stage,
At this stage, your case is very bad in this manner.
I have approached against the order of Assam Board of Revenue.
Shalo, we dismiss it. Once I dismiss this, you are finished.
Lordship,
What I am indicating, Mr. Sharma, kindly understand.
Lordships, I will withdraw this petition, Lordship. with
You
to file a-
challenge the entire thing.
And
The ADC's order, this order, ADC, the Assam Board of Revenue's order, which amounts to a confirmation in view of the 2001-3 SEC judgment, amounts to a confirmation and therefore come in a consolidated manner before this court.
for
So
appeal.
therefore, this court can exercise jurisdiction without, because here the discretionary jurisdiction is the question here for condoning the delay. Now, the court has held it to be bona fide or not bona fide. is the question. But you have not been granted the leave under 14. And in fact, the trial court should have granted you the leave as it has should have been dismissed. But the trial court, I cannot sit over that. So the only way is that you withdraw and challenge the ADC's order, the Assam Board of Revenue order, and come before this. Better.
Got it.
Okay.
With liberty.
No, this is what so not only challenge this, because this is too minuscule of a challenge here. Okay, Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner submits that taking into account that the order passed by the learned ADC Guwahati in Revenue Appeal number RA bracket M 21/2018 dated 5/10/2021 had merged with the order dated 28/8/2025 passed by the Learned Board of Revenue, Assam Board of Revenue. He would like to he would like to withdraw the instant writ petition and file a fresh writ petition assailing the order of the learned ADC of the ADC dated 5/10/2021 as well as the order dated 28/8/2025 filed by the passed by the Assam Board of Revenue. Taking into account the above, the instant writ petition stands closed on withdrawal. Liberties as sought for is granted. So and so appears for the respondent. Caveat, you are on caveat? Caveat stands discharged. You file again another caveat.
Item 10.
This item against Act 2,
Why? Anything is there? At 2?
At the PPI also. One time,
Huh?
at 2 minutes,
At 2. Okay.
or after some time.
But if it is delayed, okay, 2.
11.
Yes, what is this? Ten 2025. What is that letter?
That is page 20.
Huh?
Page 20.
Reference and directed request you take initiative for proper survey of the boundary area of number 120 and demarcate the same in order to make it free from illegal enforcement of the fishery and thereafter make assessment of the fishery. Yes, why are you challenging this?
Because, my lord, earlier tender notice was issued on 5/12/23
Ah,
for the same discharging. We participated in spite of valid highest bidder.
submission of tender paper will be accepted here. This is the tender notice,
Which one, my lord?
page 15.
Yes, my lord.
What is the date?
That is 5/12, my lord.
Where is that?
My lord, that your lordship will not find there, but in the issuing order 5/12, my lord.
How do you know?
My lord, I have the original copy.
No, the person who signed it is different. 2011-2023.
My lord, your lordship, that is, sorry, my lord, that I have not.
No, page 15, and I think 15A is the translated form.
Yes.
The original vernacular.
There. The issue,
So that is the same one. You are there at 15A.
5/12, my lord, in the issuing date, my lord. That is the official staff put up the file before the court, before the authority. Your lordship issuing that below, left side, my lord. Got it, my lord?
5/12/2023.
23. That was the date on when the tender notice was issued.
Okay, then
Then, my lord, we participated, property statute people forwarded to the government.
Hmm.
In spite of, my lord, having, being the valid highest tenderer, my lord,
Hmm.
they settled with one person.
Hmm.
One other tenderer. And we have approached this honorable court by way of writ petition 607
25 or 24. That is pending till today, my lord.
So this order of 25/1/2024 is what?
My lord, without
It has been
changing
given to somebody else. It has been given to some Gonokpara Fishery Cooperative Society.
society, and that was put into challenge, my lord.
Then,
That repetition still pending here.
then,
During the pendency, this order issued, my lord, for issuance of fresh tender.
so anyways, you are not going to get it.
My lord, if my repetition succeed, I will get it.
Which one?
Which is pending before this honorable court.
You are the highest bidder.
I am the very highest bidder, my lord.
Why?
That's why I am challenging that in before the.
Well, what is your bid? What is your name?
My name is Bedgaon Noyapara.
Huh?
Bedgaon Noyapara.
Where is that?
This is the number one in the comparative statement, my lord, my bid.
It is of some Joydev Das.
Yes, my lord.
That is Badgaon.
Badgaon.
You are Gonokpara.
No, I am not the Gonapara, my lord.
Gonokpara has got it.
Gonapara has got it, but he refused to accept it, the settlement order. And that is.
Gonokpara, you have given only 49 lakhs.
Per year, my lord.
No, you have given per year 7 lakhs.
Oh, 7 lakh, 49
Yeah.
lakh, my lord.
And they have given so high, why should do we say anything?
191 is offered, my lord, but he did not accept the settlement. The highest bidder. And the other two are not valid, my lord. That's the case pending before this court.
Anyways, you are also not valid.
I am also valid, my lord. Who?
How are you valid?
My lord, I have submitted each and every document.
No, your rate is wrong. It is in conformity with, not in
Well-
conformity with Rule 48, which says that there has to be additional 10% every year. Isn't it?
Additional 10% every year, my lord.
Where is that? Your quote is 7 lakhs each. No case, bad case.
No, my lord.
No, they are doing it very well. They want to do something very well, let them do it. And why the others are not valid? Others have withdrawn.
No, my lord, other will, or, the first, the settlement holder withdraw it. The second and third, we put into challenge before this honorable court. Because they failed to comply the submission of necessary document.
Mm.
Another.
So it has been given to Gonokpara. Why? Has been offered the first highest bid for 7 years. At the annual cumulative, all the documents submitted were found to be valid. The society has submitted call deposit of so and so, which is above 15%. The members of the society reside within 5 kilometers, which have been here. So nothing is there.
No, my lord,
No case.
no, my lord, what I am on,
I think you should wait. Let them first you win that case.
my lord, during.
You win that case, then
No, no,
you
my lord,
no, you win that case, then you come over.
No,
Now
no.
you have no business. As of now, you are not a person aggrieved.
no, my lord, I am agree because.
No, you file an IA there. In that case, it will come before
No,
me.
so-
That also I'll dispute.
In case of, my lord, only submission, my lord, in case of subsequently the tender notice issued then settlement given.
Has the order of 15/10/2024 stayed?
Beg your pardon?
Is the order dated 15/10/2024 stayed by the court?
The settlement holder, according to the government, settlement holder failed to accept the settlement order.
No. Then who has challenged this settlement, this order of 25/1/2024?
Challenge it.
Why?
Challenge it. At that time, the settlement order was issued. But subsequently, he failed to accept the tender.
So your petition has become, what happens?
There are other ground because they held valid of two tenderers who failed to fulfill the terms and conditions. And therefore, entire process I have challenged before the honorable court, which is pending for final disposal.
So,
So my humble submission, during pendency of this writ petition, my lord, government has the knowledge.
file an IA there. No case here. As of now, you have no business. As of now, you are the fifth or sixth highest bidder.
My lord,
So, no case.
my lord, suppose, my lord,
Not a fit-
my humble submission before.
Not
your
a fit
lordship,
case, Mr. For
no, there,
issuance of
there
notice.
must be a cancellation order which I could have challenged it. Because
You-
this order no way reflect. that-
You file IAD. That now they are, on the one hand, I am challenging it for giving it to me. Now they are trying to do all these things. Bifurcate it. Who there? Why should there another repetition be there?
Because that your lordship can put it in the order itself, I am doing it. With a liberty to file an
Oh.
my lord, then otherwise, they, if I file a petition, they may say that it's a separate cause of its own, why he has not filed a petition. My lord, that may crop up, my lord, that's why I submit before your lordship.
As of now, you have no locus here.
Because I
No,
have a look at, because, my lord, I'm aggrieved by the order. Why, my lord, I am submitting it? Because I am at the temporary process is still, was still at that time pending. That has not been completed. And because of this under judicial scrutiny, the law is that the government should take its hand off, my lord.
no. The government should keep on going ahead to do
My
whatever is required.
Cement judgment, my lord.
Huh?
Cement judgment.
Three bench judgment. Very well.
Cement. I have the. copy, my lord.
Siemens judgment. So what we do is, we dismiss it by saying that that law does not apply. The division bench will look
I'm-
into that judgment and
Yeah.
allow you. Give it to me.
No, my lord,
Uh,
when your lordship expressed that
This is not the. Yeah. I give you the liberty to come again once you win that case.
my lord, that,
Once you win that case, I give you the liberty.
no, my lord,
Or file an I.
I'll file an IA, your lordship.
But you see, I give you, as of now, I say that Lucas has not come for you. You will be given the liberty to approach this court
No,
if you
that-
win that case, or you are at liberty to file an I.
My lord, that may be your lordship in your order itself.
But this court is not going to entertain this. As of now, you have no business. What do you say?
Your lordship, Annexer C, my lord, he is the fourth highest bidder, my lord.
Annexer C.
Annexer C pays 18, my lord.
Ah. So it has been given to somebody else.
My,
And the petitioner is number 4.
fourth, my lord,
It's the fourth highest financial bid,
my lord.
as well as documents submitted in terms were found valid. So all three were found valid.
Valid, my lord.
So now whether the 1 and 2 leaves or not, that is a subject matter which will be challenged. As of now, if the other people, number 1 comes, number 2
Oh,
comes, number 3
three.
comes, those are different things.
My lord,
But they have to be successful in getting rid of this 25-1.
my lord.
No, I will be allowed to withdraw subject to filing an application, my lord.
Mr. Escotoki, the learned counsel, heard Mr. Escotoki, the learned counsel appearing on behalf of the petitioner. Ms. S. Setia, the learned counsel who appears on behalf of the fishery department of the government of Assam. The present writ petition has been filed by the petitioner challenging a communication dated, what is the date? 10/10/2025, issued by the Secretary to the Government of Assam Fishery Department, whereby directing the District Commissioner Borpeta District to carry out proper survey for demarcation and ensuring the boundary of number 1 fishery, river fishery in Borpeta District and retendering of the fishery. Mr. S. Mr. Escotoki, the learned counsel appearing on behalf of the petitioner, submits that the petitioner is the fourth highest bidder in respect to a tender proceeding for settlement of number 1 Solkua River Fishery in Borpeta district. Full stop. This court have duly taken note of the order dated 25/1/2024 passed by the Fishery Department, whereby it was decided that the fishery in question would be handed over to one MS Gonokpara Fishery Cooperative Society Limited. Full stop. Mr. S. Kotoki submits that there is a challenge to the said order dated 25/1/2024 before this court, which is registered as WPC number
607 of 24.
607 of 2024.
24.
And the writ petition is presently pending. Full stop. Taking into account that till the order dated 25/1/2024 remains, and the respondent number and two other fisheries, namely Bahari Reserve Gao Mean Samavai Samiti and Pat Bausi Mean Samavai Samiti, are declared to be not eligible, the petitioner herein would not have a right over the fishery in question. As such, full stop. Under such circumstances, the learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant writ petition with a liberty to file an interlocutory application in WPC number so and so.
607 of
Full stop. Taking into account the same, the instant writ petition therefore stands closed on withdrawal. Liberty, however, is given to the petitioner, who is also the petitioner in WPC number so and so, to file an interlocutory application, if so advised.
Item 24.
What is this?
Basically, this the tender process was initiated to settle the fisheries. And our grievance is that before the improved work order pass, we have lost some complaint that the person who participated in the selection process
Oh, 100%.
yes,
What has happened to you?
neighborhood certificate
Huh?
as well as neighborhood certificate This certificate is necessary as per the tender process. And they have we have filed additional affidavit, we kindly have our additional affidavit. A report has been provided to us by the authorities, for this.
So what are you challenging here?
The inaction on the part of the respondent office to consider our representation as well as the improved work order that has been challenged. Because the person who has.
Set aside and quash the impugn order dated so and so 18/8/2025. What is that order?
That order is at lordship page
18/8.
49. Slide 49.
Brahmaputra Part 1 Fishery of Sipsagar with Notun Gotonga Dhrubajyoti SHS Notun Sipsagar for a period of 7 years.
7 years.
Now, why are you challenging?
The certificate, the necessary document as per the tender NIT, necessary document, one is that 100% fishermen and two is the neighborhood certificate. They must have to be the,
And the neighborhood survey were not given.
they are not given us. And they have annexed some document that is of 2019 that we have annexed in our additional affidavit, page 68.
So here there is a mention that there is a certificate given by the revenue circle officer that members of the said society reside within 3 kilometers of the fishery and thus fulfills the condition of inhabitants in the neighborhood.
In our additional affidavit, we have entered the document, additional affidavit, page 68.
Page
68. Running page 68.
67.
68.
68. Additional share part submission with reference, I have the honor to state that as per your
The tier
instruction
number
conveyed the tender process from Iman, the total number you were filed for the settlement will say these four tenders were rejected by Assembly and the remaining three to the higher authority. So there is one selected. There is one selected. What is your name?
Lordship,
Oh,
our name is
Anukaran.
Ankur, joint liability.
Ankuran, Jyotia so-and-so had lodged a complaint seeking cancellation of the other two tenders on the ground of submission of invalid document. The tender process was re-verified and found to be ordered in conformity with the comparative statement. Verification, date of experience. Notun Gotanga. Date of experience certificate 11/2. Date of issue of 100% 10/9. Date of Riverside dweller certificate so and so. So what is wrong?
Lordship. In additional affidavit, Lordship, got page 68, yes,
Page 68.
page 68. Page 68, Lordship, and say number 3 and 4, the date of issue of 100% fisherman certificate is respect number 80 of 2019. And the next column number 4, till number 4, date of Riverside dweller. This is the not the neighborhood certificate. This is the this person might be Lordship residing in the back of river or somewhere. Lordship. Dweller certificate is of Riverside dweller, not the Lordship neighborhood certificate. They are
The
not.
neighborhood certificate is there, na?
No, Lordship. The certificate only see Lordship, the serial number 4.
Furnished.
Dweller certificate, Lordship, they reside more than Lordship 8.
So you
8
asked for, did you ask for that certificate, neighborhood, under RTI?
Yes, Lordship, that has not been,
Did you get the comparative statement?
not yet, Lordship. This ITI application.
And what is this photo? Page 72.
Page 72 is Lordship. And this is Lordship, this is the social media Lordship posts they have posted Lordship.
Who has posted?
This some 18.
Okay. We do one thing. We just issue a notice.
I mean,
No
Lordship,
case.
issue notice and also Lordship issue notice and also may call for the record Lordship, like we have not been provided the comparative statement also.
You are there?
My lord, I
What is it? Tell me, you have a neighborhood certificate?
My lord, as per their complaint, my lord. My lord, I am the valid hire bidder. My bid is.
I'm not on that. He's not on the valid hire. He is on 2 points.
My lord,
One is, you don't have a neighborhood certificate. And the second is 100% fisher.
yes.
These are 2 points.
My lord.
Now, do you have it?
My lord, I have it, my lord.
True.
My lord, I'll file it by way of an affidavit. If your lordship wants, then I can peruse it on the next.
You are on caveat?
Yes, ma'am.
Oh, you must be having it then.
My lord, at present, I don't have. I will take it.
Okay, we make it returnable by Monday?
This Monday, my lord.
Yes.
My lord, they are from Sipsagar. Can it?
Till that stay.
My lord, we have already taken over the proposal.
Don't do it any further. You are on caveat. You have to have the documents. This is the small issue. It's not a big issue. And you had appeared on the last occasion.
My lord.
You know everywhere what was this. So therefore, these are the 2 things. One is his allegation that you don't have a neighborhood certificate, and second is you don't have a 100% fisherman. That's his allegation. Now there is an inquiry being held wherein it says that the river dweller certificate is there, which cannot be compared with a 100% fisherman certificate. So therefore, where is it? You should have been more clear. You are being on caveat. You are not here to accept notice. Are you? Only to accept notice.
But my lord.
So take the notice along with the stay. Very good. By Monday, till Monday, because of your appearance, now you cannot run because it will have a deemed knowledge upon your client that there is a stay.
My lord, my lord, there initially after the settlement order was
Okay,
issued.
we stay there.
My lord, let it be on Monday, I'll protect the document.
Okay, till then.
Lord, I have
then-
already taken over the possession. I have.
Very
the
well.
possession
Don't
certificate.
run for the last Saturday, Sunday. Don't run. Monday we again take it up.
My lord, their entire case is the first complaint. which
Entire
they have
case is
lodged.
on 2 documents.
My lord,
produce those two documents
My lord,
at 2 o'clock.
today.
Then no stay. These two documents, whether you have a 100% fisherman and a neighborhood certificate. That's all. I don't require more. And if your person has it, have it. If you don't have it, then it's gone. Matter over. And then we'll ask for the records. You show me prima facie. So being in caveat, you have to be ready. You can't just stick notice out here. 2 o'clock.
My lord.
Fantastic.
Right.
Oh.
May I please, Your Lordship?
Hmm.
The petitioner, Your Lordship, hearing the registered association of Your Lordship. E-tempo vehicle owners, Your Lordship. They are aggrieved by action of the respondent authority by which, Your Lordship, they have permanently stopped from plying their vehicles, Your Lordship, within Dibrugarh municipality area.
Where is that order?
Lordship, Your Lordship will get it at page 55, Your Lordship. Two things, Your Lordship. What they have done, Your Lordship. Permit, so far as we are concerned, Your Lordship, is exempted by the central government, Your Lordship, by bringing in necessary modification in the Motor Vehicle Act, Your Lordship. Now, government.
So now you are not being allowed to run in other areas.
Lordship. Now your Lordship will kindly see why we only, Your Lordship. That is not reflected from the order, Your Lordship. Number one. Why not other three wheelers, Your Lordship, like auto? Now, on the one hand, Your Lordship, the government, government is, Your Lordship, giving incentives for buying, Your Lordship, these e-vehicles, Your Lordship, battery rickshaws, Your Lordship, so that they can in long run, Your Lordship, replace these diesel vehicles, Your Lordship.
Earlier at page 51,
Lordship.
the chairman RTA so and so to remove all 15-year-old three-wheelers
Lordship.
so and so,
And your
which are
lordship.
unfit. And those vehicles shall be replaced by the EV autos only.
EV autos, Your Lordship. On the one hand, Your Lordship, they are promoting EV autos. On the other, Your Lordship, they are not allowing these EV autos to fly in the particular areas, Your Lordship. And secondly, Your Lordship, what they have introduced, purchasing letter, Your Lordship, permit purchasing letter. Although we are not required to have any permit from the motor vehicle authorities, Your Lordship, they have, Your Lordship, introduced it in a different way. Your Lordship, only on, in the permit purchase letter, it was written that only on this route it will be operated, and based on that, Your Lordship, our autos will be allowed to purchase, Your Lordship. Now, Your Lordship, this they can.
So are you saying that if a person goes out there
Lordship,
but does not want a permit,
Lordship,
he can run anywhere?
no, they can, Your Lordship, put restriction, Your Lordship, but that restriction, Your Lordship, suppose, Your Lordship, they are putting a no entry, Your Lordship, for particular side, Your Lordship. Now, Your Lordship, that will be applicable for all, Your Lordship. Now, why only e-vehicles, Your Lordship? Why not autos? That's the question. That's arbitrary. Why only one class of, Your Lordship, vehicles are not allowed to ply, Your Lordship, and rest were allowed, Your Lordship? Will it not be discriminatory, Your Lordship?
Your case therefore is that you don't mind flying in a particular route, provided the same is applicable
Applicable
for all other
All other vehicles.
autos.
Autos and other vehicles, whatever it is, Your Lordship.
They should also have specific routes.
Lordship, that is what, Your Lordship, my case.
Lordship, may kindly have a look, page 43 for a moment.
40?
43, my lord, Annexure F.
Ah.
Lordship, I got it, my lord.
Yes.
It is a road permission letter for EV auto. This such and such address, and then after verification of documents and declarations submitted by you to this office, you are hereby found eligible to apply the EV auto on the mentioned road above. Please note that the road may be changed at any time by order of RTA Dibrugarh in interest of smooth transportation and traffic management. Also, it is ordered not to apply the EV auto in Dibrugarh municipality area without prior permission. Further, this letter could not be treated in any case as a piece of documents as permit.
Permit we don't require.
This is the route permission letter issued before purchasing the EV auto. They've agreed to the route that we are flying on particular route only. We're not going to fly in other routes. And after that, they have purchased the vehicle. And now they are agreed with all
No, their agree is this.
the other
that-
three-wheelers.
Why other three-wheelers are allowed to roam around everywhere? But only them, they are restricted to a specific route. That's it.
That instruction I will get, my lord.
You get that
Malad.
instruction as to the why you are, or you have specific routes for everybody.
Everybody, yes, yes,
Then
yes.
they won't have any problem.
Yes, lordship may issue a short notice. Next Friday, I will.
No, short notes. Very short notes. Issue notice making it returnable on 28/11/2025. Ms. MD Bora accepts notice on behalf of respondent numbers
2 and 5, my lord.
125, na?
Yes, my lord.
125. And what about why you are making the Dibrugarh Municipal Corporation as a party? Are they, do they have
Because-
anything?
It is the decision taken by the RTA.
This is
That's why they-
RTA, Your Worship.
Huh?
Normally, Your Worship, what happens?
This is decision to whom, by whom?
RTA, my lord.
RTA.
Regional Transport Authority.
So that is it. Why you are making the Dibrugarh Municipal Corporation?
Lordship may strike it off, Your Lord.
They are not necessary because they are putting it.
Lordship.
Any issue, any level? Heard Mr. S. Bhattakur, the learned counsel appearing on behalf of the petitioner. Ms. M. D. Bora appears on behalf of the respondent numbers 1 to 5. At the outset, Mr. S. Bhattakur submitted
three of
that
them.
the presence of
One,
the
two,
respondent number 6 to 8 are not essential for the purpose of, for the adjudication of the present proceedings. He therefore submits that the names of the respondent numbers 6 to 8 be struck off from the array of parties. Accordingly, the names of the respondent numbers 6 to 8 are struck off. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court by Monday.
Sure.
And the registry shall accordingly make necessary correction in the cause title as well as also update the same in the CIS. So the issue notice making it returnable on 28/11/2025. Ms. M. D. Bora accepts notice on behalf of the respondent number
1, 2, and
5.
5. 1, 2, and 5, my lord.
1, 2,
And 5.
4, 4.
4, my senior is appearing.
Why? Additional District Government Regional Transport Authority?
DC representing by.
No, Regional Transport Authority.
Yes, lordship, he's the deputy commissioner. He's the.
No,
RTA.
4, 4.
The
These are all
three-
regional, they have no business. You have all, transport everybody.
Lordship, I'll get.
1 to 5. The petitioners herein is an association of EV tempo vehicles owners who are aggrieved by the action on the part of the respondent authorities in only permitting the
Twenty.
petitioner
28.
only permitting the
No.
members of the petitioner
28.
association to ply or ply in specific routes provided in the route permission letter for EV auto. Whereas all other commercial vehicles like autos, etc., are being permitted to run without specific routes. Full stop. Mr. S. Pottakur, the learned counsel appearing on behalf of the petitioner submits that on one hand, it is the decision of the respondent authorities to promote EV autos as would be seen from their own resolutions adopted in various minutes of the meeting. And on the other hand, the members of the petitioner association are only permitted to run in specific routes, whereas other vehicles, commercial vehicles, which run on fossil fuel,
Lords,
are permitted to run in any without specific routes. So taking into account the above submission, the learned counsel appearing on behalf, standing counsel appearing on behalf of the transport department is directed to obtain instruction as to whether the other commercial vehicles are being allowed to run by the respondent authorities without there being any specific routes.
Lordship, deeply obliged.
deeply obliged.
26.
Pursuant to the leave granted by Lordship, we will file the second leave petition. Now, it's a, in fact, it's the third leave petition. Lord, here, my lord, the other point is hesitated in the other case. And we have also filed a writ appeal against the order passed in the IA.
What has happened?
Lord, the whole matter has been fixed on next Friday.
But that is against an interim order.
Yes. Now, my lord, here in this case, if your lordship should kindly. What is the number? 371.
Where is the other petition? Where is the first petition? Listed today.
Other matter is listed.
Today.
Yes. Item 18. Now, my lord, if your lordship would kindly come to page 101. Because one of the ground of rejection of our technical bid was that we did not fulfill this requirement. 2.2.2.2. Financial capacity. The bidder shall have a minimum net worth financial capacity of amount equal to 5% of the estimated project cost at the close of the preceding financial year. Lord, the financial year closes at 31/3/25. However, my lord, in terms of the provisions of the Income Tax Act, Lordship knows, my lord, that audit and all these are to be done by 30th of September.
This is this year.
Yes, this year.
So audited now will go to 10th of December.
10th, now it will go to 10th of December. In any case, my lord, in terms of page 102, my lord, sorry, 104, 2.2.7.2 towards the bottom of page, my lord, 104. In case the annual accounts for the last financial year are not audited, and therefore the bidder cannot make it available, the bidder shall give an undertaking to this effect, and statutory auditor shall certify the same. In such a case, the bidder shall provide audited annual return for 5 years, preceding the year for which the audited annual report is not being provided. So we complied with this, my lord. So where is the question of rejecting our?
No, this clause, no problem. That day also I said to him, he cannot come up with this. This is wrong. But what about the number one?
No, regarding number one, my lord, I was only wondering, my lord, since writ appellate court is in session of the matter, how your lordship should take it, my lord.
I can
Because
dismiss,
it
I
may-
can only do one thing, dismiss your petition so that you can go to the division bench. No, because I can't transfer it to the division bench. I have no power.
I know.
Unless you seek an administrative permission from the chief to take this. That is the only way out.
Yes.
Otherwise, I can't. Once, what happened, when I was very initially taking up, there were some mention being, you may remember that matter. When on the other hand, Mr. NNB Chaudhary was there. Remember that cement of ACC block?
Ha, ha, ha.
Remember that matter?
Yes, my lord, that in the tribal area.
That tribal area.
Ah.
So that matter was, I sent it there.
Ah.
Again, it came back.
Yes.
Because you see, the single judge doesn't have the jurisdiction to put it before the division
Correct.
bench.
Absolutely. No, but the only problem is, in the other matter, since Lordship has fixed the, division bench has fixed the matter on Friday next, that is, I think, 26th, 28th. So that is the only problem. Otherwise, I can argue, there is no difficulty.
But that is against the order as to of Justice Rajesh Majumdar.
Yes. But,
On-
end of the day, my lord, that is something to do with that clause 2.2.2.4, the other point. That's what I was, that's question of propriety, my lord, is nothing else.
That is your lookout. You want to take an adjournment, you can very well take an adjournment. I can't do it.
We'll address your lordship.
Huh?
We'll address your lordship.
But you should address me on the other point, because you see, if
Yes.
I am satisfied with the first repetition,
Yes.
then only the second comes.
Yes.
Because because what has happened, the first repetition, my only problem which I am facing is, you gave an undertaking, and in the undertaking, it is not in that particular format.
No, for undertaking, there is no format, my lord.
No, there is a format.
Oh, there's a format. There's no format, my lord.
There is no
Undertaking,
format.
there's no format.
There is no format.
No, my lord. I can show, my
We
lord.
have to declare where, also there is no collapse date. for which we are looking.
Your undertaking has to have a particular thing. There, it
No,
says,
I'll just place it, my lord.
where is that clause?
Page number 102.
Yes, 102. 102.
Towards the bottom of the page.
There should be-
history of collapse of
There should
superstructure.
not be history of collapse of so and so, so and so, so and so.
Ah,
You,
then
if I
it will be
remember
not-
correctly, in your undertaking, you said this clause is bad.
Not exactly, my lord.
Let's see that undertaking.
No, yes, I have annexed it. No. The undertaking is at page number, one second, sir. Yeah, page number 124. Now, after quoting that in the last para at page 124, my lord.
Hmm.
subject to the
Undertaking is given,
foregoing-
this undertaking is without prejudice to all rights of the bidders, including to avail constitutional remedy.
Yes.
Finally, the
Last
matter
paragraph.
in respect is to be resolved
Subject
without
to the
modality.
foregoing, it is disclosed in respect of unforeseen, unforeseeable collapse of part of spans on 34/46 in respect of Sultanganj Aguat project. Under instruction of the employer therein, that is the Bihar thing, and as per the order dated of the High Court of Judicature at Patna, so and so, re-execution of the collapsed part of the span of work by the bidder is in progress under the force majeure clause 21.6, read with the contract as a whole. Finally, the matter in respect thereof is to be resolved within the modalities of the contract agreement therein as a whole. Accordingly, understanding is given, undertaking is given. This undertaking is without prejudice to all rights of the bidder, including to avail the constitutional remedies and interim relief simultaneously to prevent possibility of declaration of non-responsive status to the bidder by doctored misuse of clause so and so, so and so, so and so. Therefore, all that we are trying to say is, my lord, the clause as it stands, my lord, simpliciter, it does not factor in the force majeure conditions. That is the main thing, my lord.
So there was no inquiry carried out in respect to this.
In fact, it was, we were given a task of redesigning and then going ahead with the thing. And we never
No, that is
blacklisted
okay,
anything.
but there is no inquiry also.
No. And regarding, my lord, some of the claims, there is an arbitration provided that will avail.
But as such, my lord, we have not been blacklisted or nothing has been done by Bihar employer. And no claim has been raised against us. Therefore, we are saying, my lord, when you are not factoring in the force majeure aspect, how can you act on it? And my lord, if your lordship would kindly come to page number 1, which is the page? So, explanation. Yesterday we found out that I one spot was 1.3.1 meter. Now, if your lordship would kindly come to page number 117, my lord. Page 117.
Yes.
They have a right to seek this clarification, my lord. 3.1.4. To facilitate evaluation of technical bid, the authority may at its sole discretion seek clarification in writing from any bidder regarding its technical bid. Such clarification shall be provided within the time specified by the authority for this purpose. Any request for clarification and all clarification in response thereto shall be in writing. The bids will be examined and evaluated in accordance with the provisions as set out in section 3. The authority will subsequently flag issues, if any, with the data updated by the bidder. If a bidder does not provide the clarification sought for under clause 3.1.4 above within the prescribed time, its bid may be liable to be rejected. In case the bid is not rejected, the authority may proceed to evaluate the bid by considering the particular requiring clarification to the best of his understanding, and bidder shall be barred from subsequently questioning such interpretation of the authority. So they could have very well asked us, my lord. And the same
now
party.
now they require-
More projects.
It is the undertaking in this regard shall be submitted along with the bid.
Yes. So, my lord, there is a specific provision in the form of clause 3.1.4 that if they have any issues with regard to accepting the technical bid, they can very well seek the clarification. Nothing prevented that.
But that is again discretion.
No, my lord, lordship, in administrative law, lordship knows discretion is yes, but there is always a duty to act fairly, my lord. Discretion does not mean, otherwise what sense does it make of providing this provision, my lord? And kindly see the mandatory nature of it. Is it evident from 3.1.5? It says, if clarification sought for is not provided, then the bid is liable to be rejected. Therefore, in that factual context, my lord, the purport of 3.1.4 has to be judged.
No, in case the bid is not rejected, then the next line.
Yes, my lord.
So it is may or may not.
No, what I'm saying is when normally this is how the language is, couched, my lord. Similar clauses we find in other contracts also. Yes, at the discretion. But then discretion is not the ultimate thing, my lord. Lordship will test it, whether in the facts of this case, this discretion ought to have been exercised or not. The Bihar employer has not done anything. I am undertaking 4 other projects. Guwahati Bridge. I am undertaking, my lord, that Pancharatna Bridge. I have completed Bhomuraguri Bridge. I have the Jogi Gopal is Pancharatna. Then I have been given this, my lord, the new work from Kamakya railway station to that Azara, my lord, that 1200 crore thing. Because it's an elephant corridor, so an elevated, my lord, track is being laid down, and that work also I am doing.
What are your representations dated 31/5 and 5/7 in your undertaking you have mentioned?
Yes. Sir. It was in page 124. Huh? 210, my lord. No, not 210. other petition. Page. Well, this petition starts at page number 270. Yeah. Presentation that we have. The other file is there. No, that representation is available in the other writ petition because item number 18.
Item number 18.
That file is there. Petition number. Page 200. 5051. Let me go to 210 Miller.
And what is annexure 17
Of Miller,
of this repetition?
earlier one Miller,
This one.
present one. What's
Request for proposal for construction of substructure of important bridge. This is different, no? Gorakhpur some.
a different work, Miller? We have
Why
in
we-
this
have you
example
include-
for the simple reason, Miller.
Hmm.
And the second ground, there they have accepted. And we have been on financial part, we could not qualify, we have been made L3. But Millard, we gave the same document as they have given here, there they have accepted. And
There they have it. This is by some other, not NEF.
Northeastern Railway. Same railway, Miller.
No, it's a Gorak thing.
To NEF. This
Not
is
by
not-
us.
Same government of India, same railway ministry.
And what is this NF railway annexure 15 page 140?
My lord, this is the work that Azara Kamakha project, my lord.
This is given by NF railway.
Yes,
By them.
to me, yes. On 4th of August.
And here also they had a clause similar.
Similar. A similar, no, I am not saying a similar, no.
It's a lots of minor piece project regarding elephant corridor, that line loss, before bill line loss.
It is also a work of 1200 crore. na?
How much is the work?
1200 crore, my lord, 1100 and almost 1200.
1,245 crore,
Yes,
49.
Hmm.
And this project?
the instant project, my lord. The value of L&T is 1300 crore and the value of EPSCon is 1700 crore. And our rate is much below, my lord, which we have not disclosed. Much below. An estimated value in the tender, it was 1500.
Where is the that document?
Which one? my lord?
In this file, the earlier file, that those letters which I was saying, 31/5/2025 and 5/7.
211 Miller. Even the Majuli bridge also has been given to the petitioner, my lord, now.
And this is one, and the second one is, 5/7. 5/7, where is that?
200, page 210, my lord.
No, that I read.
These
210
are
is
the
31.
2010, 210 and 211,
So 211 is 31/5.
31.5.
And what is 5/7?
No, 3/7, 2005. Mail was sent separately, my lord, but this is the letter, 3/7,
3/7 is there.
210.
So this is only asking for a meeting, huh?
Yes.
Now, Mr. Chaudhary, by any chance,
Yes, my lord.
if we are to interfere,
Ah.
would it not impact the entire tender has to go then? Has to,
Yes.
because they will impact many other bidders who
How many
would have
bidders were
otherwise
there?
participated. Because you on your own have given
Total,
instant.
there were total 6 bidders, my
No,
lord.
not here. There might be others also who may not have
There were six.
participated.
NP is there, Malayapuram is
No,
there,
it is-
various.
It is from your own document, it is apparent. There are many other bidders who were there, but they had fallen breeze and all. So you want to now try to incorporate, you had by this communication dated 31/5/2025 requested for deletion of that. Now, that is another aspect about deletion. Now you are on the question of reasonableness of the clause to the effect
Yes.
that whatever may be, you may have a clause, I may have given you that undertaking to that effect, you have to ask me. Meaning thereby you want that whenever there is a clause, there is a requirement to ask as to whether it has happened beyond your control or not.
And, my lord, that would be consistent with principles of natural justice and Article 14 also. In that case, I'll get an opportunity to explain my case. It is for the authority to consider, not to consider. If they consider by giving a reasoned order, very well. If they don't, I'll get an opportunity of.
Did you have a meeting post 3/7?
Yes.
You see, there was a meeting by which earlier there was a notice inviting tender initially issued which had 5 years. Now they have made it 3 years. So this meeting has happened on the basis of there was some form of meeting. When did this change happen?
A change happened on, my lord. I'm giving the date, my lord. Second wala. 1 second. 23/7.
23/7. So after 3/7, that document which you have enclosed at page 210 of the earlier petition, there was some form of a meeting or not?
Yes, yes.
Then what happened there?
So in fact, my lord, if 5 year remains, then L&T cannot make it because they have got instance of within 5 years.
No,
That we
it's
have to-
okay, but there was a meeting on 3/7, after 3/7. Because you gave on 31/5, followed by 3/7.
That thing was of the pre-bid meeting, there, I don't think we could have impressed upon them to remove this.
No, because they made it from 3 to 5, 5 to 3. So this could have also been done.
Whether, in that case, they could have, if they had listened to us, they would have altogether removed it.
They could have removed it
They
then.
have not done it.
So therefore, were you not heard on the deletion of that? My question is there.
Really, my lord.
No, because if L&T was heard,
Goes by our, terms, then in that page 211 of the first writ petition, our request to the railway board, we say this is an unreasonable discriminatory clause, you remove it.
you removed it.
That was our perspective.
Yeah, perfect. Now, therefore, this was followed by 3-7, you asked for a meeting.
Yes.
When you had that meeting on 3-7, after that you had a meeting.
Ah.
Because therefore, this is very important that they have reduced from 5 to 3.
Now, my lord, this is the outcome at page 148 of the first writ petition. Please come to 148.
Yes. This is it. So this is prior to, on what basis this was done? Let us see.
In the pre-bid meetings, this happened, my lord, sometimes in August, na?
22 lots.
23, na? 23-7.
23-7, na?
Yes. Please come to 148, my lord.
So there, after this, there was a corrigendum issued.
Hmm.
No, but
That's
this,
the one
this,
which
this
is talking-
clause appears to be original.
No, my lord, original is at page number 132.
Okay.
Original is at 132 of the first petition. 132. There should not be history of collapse of superstructure, substructure of any span of a bridge, flyover, viaduct, metro ring, work during construction in the last 5 years, ending first day of the previous month. One in which the tender is invited, undertaking in the shall be submitted along with the bid. Then please come to 148, my lord.
Now,
which was-
when was, pursuant to this, there was this pre-bid meeting.
No, after this, there is, the first one is at page 132, my lord.
Uh-huh.
Then thereafter, the pre-bid meeting was there. Then it was
That
sent
is on
to-
23-7.
Huh.
So pursuant to this, you must have written that letter of 31-5
Yes.
and
In fact,
asked
four.
for, this was issued when? Obviously, this must have been issued then, because let us see 210.
I think it is 19.5, my lord. Can you give the date? ये वाला, ये वाला. 19.5 is the original. My lord, kindly take note, my lord. 19.5 was the original tender, RFP. Then,
Kindly come to 214.
of the first petition.
Yes.
Yes,
Yeah, therefore you are referring to that original 5 years.
yes.
So therefore, this is,
On this date, this was the clause.
this was a clause. So pursuant to this has happened. And thereafter, there was some form of a meeting or something. So then they considered it and made it 3 years.
That reduction of 5 to 3 years was not done at our NC.
No, maybe-
There was this,
No, yours was there, but that was not considered.
not.
And they have reduced it to 3 years. So if they have now reduced it to 3 years, so now the question of challenge to this 3 years would be on the principle that it is arbitrary, absolutely arbitrary. But you knew that this 3 years means without any, nothing is there. This is just a clause. Earlier it was 5 years, now 3 years. That cannot be any accident.
That's why, my lord, we submitted the tender on which day? 27/8, we submitted the tender and we filed the writ petition on 26. One date before, my lord. Our writ petition is earlier in point of time.
You filed it on 28/8.
After submitting the tender, they have filed it.
No.
After submitting the tender, they have filed the petition also.
You filed it on 28/8.
Is it 28?
No, no.
Even the first order also reflected the same, Lordship. Order of the honorable courts order also reflected the same.
Eventually filed on 28. Anyway, date of registry is still BS 28.
Huh?
Registry's seal perhaps it bears 28, Miller.
No, because your affidavit, in your affidavit, you have stated that you have submitted, it is on 26 you have made the affidavit.
No.
26 you made the affidavit, but it was filed one
But
day
it was
after.
presented on 28. Actually, affidavit was done on 26, but I think it was presented before.
Filing was on 29.
Even Lordship, we have.
Filing assistant is on
Amar,
29
29 the issue, please. We have
and
received
it was written as 26.
I think they were under the impression that it was 26 because the affidavit was done on 26. Well, there my humble submission would be, our perspective from the very beginning was very clear. That this clause is unreasonable, therefore might as well don't have it. But the reduction was done at the instance of the L1 bidder, that is the whom we have included as a respondent now. Because if it is 5 years, perhaps they cannot qualify. And if your lordships would kindly come to that corrigendum also.
148.
Kindly similar original clause is on the left hand side. Left hand side. Deletion of above clause so and so modification, as there should not be a history of collapse of superstructure, substructure of any span, flyover, viaduct, metro line work during the construction service in the last 6 years ending last day of the month previous to the one in which the tender is invited.
So here they were considering your request also. Because they had deletion or modification.
No, they were not considering it.
No, no, obviously,
Ah.
deletion of the above clause or modification.
Of course, they have used it, my lord.
And then they made a clarification and said that it would be 3 years.
3 years. Clarification, now the what was.
Has been incorporated in
unintended
Iman, the
was-
collapse of the super so and so, failure or so and so permanent area will be considered in this clause only.
Ah.
Now where do I get the 3 years now? How did it become 3 years? Oh, here, the
The-
clarification has been incorporated in the Iman. So they have incorporated bidder undertake the railway sector into it influence.
Page 99, Lordship.
Page?
99, Lordship.
99 is the clause as it stands today.
Lordship, 99. After that pre-bid meeting, Lordship. 99.
No, but this is not there in the pre-bid meeting.
Lordship.
So when did they change this?
After that, Lordship. After the.
So this must have happened subsequent to 23/7.
Lordship, Lordship.
Correct.
Oh, it is. Okay.
How do you take care of AFCONs?
Abscon, my lord. Abscon, my lord, Abscon also has similar history.
No, AFCON's judgment.
Paragraph 80.
Oh, acha. No, my lord, abscon judgment, it is not an absolute proposition of law applicable in all cases. Possible have to look at the attending facts and circumstances. My lord, I do appreciate that the recent trend of judgment of the Supreme Court shows, my lord, that normally courts should give due deference to the, understanding of the employer regarding interpretation of the clause. Here I am not exactly on the interpretation of the clause. We are on a slightly different plane. Our case is you have inserted a clause which is not capable of application, madam. And if you apply it, then an element of arbitrariness creeps in. That is the case, madam. Had it been a case where a particular clause has been interpreted by the employer in a particular manner, it is also capable of interpreting in another manner, in which case Supreme Court says, court will maintain his hands off principle and stay away.
as long as it does not result in massive arbitrariness or something like that. Here in this case, I am a contractor who is undertaking 4 major projects at the present time. In one of the contract was given to me, Milord, on August, 1200 crore.
But they didn't have that clause. Problem,
that's-
no, problem arises is in view of the various
So,
Supreme Court judgments,
Let us-
my
let us-
hands are
let us-
tied.
Let us, for the argument's sake, take it that the clause has been inserted with a purpose. Let us take it, Milord. But while implementing it, is it possible to, lay down a Milord clear-cut guideline? Kindly see, Milord. It is in that context we are making this submission. And kindly see, Milord, their arbitrariness, why they have invoked 2.2.2.2.4?
That is.
No, I'm just saying that means they are trying to, Milord, make the rejection more strong by adding one more ground.
No, actually, that is being done for the purpose, not for any other purpose, that by any chance, because of Justice Ate's order is being interfered with, then they have another to fall back. That is what I could get. But be that as it may, I think, Mr. Chaudhary, there are two things. Let me issue a notice,
In
short
this
notice,
case, Milord.
2 weeks. You serve L&T also.
Yes, will do.
And then we consider, because passing an interim order of this case out here at this stage would not be proper. And as I am taking up the bench, I will give preference to finish up the matter.
Yes, yes.
That is the way, because if I have to give, then again, your problem is Ronak. with it.
My only prayer is, Milord, would your lordships take up the matter before 5th? Because the L&T has time till 5th to, Milord, submit the
No, I will say,
performance.
no,
review.
I can very well observe one thing,
Yes,
that not granting an interim order
yes,
shall not create any equity in
yes,
favor.
yes.
I think that is the best way.
Yes.
This is the. But then also one needs to hear this and
Sir.
flesh it out, because this matter cannot go for long.
That's why I was wondering, Milord, lordship will give us liberty, we'll serve Dusty.
No, that too, whenever I allow, I
And
give.
therefore, if your lordship will kindly fix it before 5th, Milord, because that is the day when they will have time till then to submit the performance guarantee, and they can sign the agreement.
But this is too short a period. Only
We'll-
one.
We'll serve by Dusty. Milord.
No, you are there, but they will come in. So I'll ask them to file their reply
Yes,
before that. Let us have it on 8th of December
Milord.
at 2 p.m. I think best. They let them also file a affidavit.
We have filed also. In this case, we have filed.
Huh?
First one, we have filed.
No, second one.
Second one, sir.
Not on first one. Issue notice making it returnable on 8/12/2025 at 2 p.m. Mr. K. Gogoi accepts notice on behalf of the respondent number 1 and 2. Full stop. Extra copies of the writ petition be served upon him during the course of day. As regards the respondent number 3, the petitioner shall take steps by way of speed post by tomorrow, by Monday. Full stop. In addition to that, the petitioner is also granted the liberty to effect service by way of dusty written to the registry of this court upon the respondent number 3, and thereupon file an affidavit of service on or before the next date. The service by way of dusty be meted out upon the respondent number 3 on or before 27th of November.
My lord.
You complete the dusty upon respondent
By
number 3
27th.
by 27th of
Yes.
November. Otherwise, they may again say last
Yes, no, we'll do that. We'll do it.
27th of November. Full stop. The petitioner herein have already filed another writ petition, being WPC number 5051/2025, whereby the
This case is big tough.
petitioner have assailed clause, where is that, where is it?
Milord,
Where is that
page
clause?
in the new petition, page number 101,
101. Have assailed the clause,
102, Milord.
clause 2.2.2.4,
Then within bracket.
Roman
3,
3,
within bracket Roman 2,
Roman 2,
then
small 2,
numerical 2.
bracket numerical 2 of the notice inviting tender. Dated 19/5/2025. On the ground that the said term violates the mandate of Article 14 of the Constitution, apart from being vague and grants unqualified discretion upon the respondent authorities. The learned counsel appearing, senior counsel appearing on behalf of the petitioner submitted that that pursuant to the issuance of the notice inviting tender on 19/5/2025, the petitioner had issued a communication on 31/5/2025 detailing out the petitioner's various credentials and sought for deletion of the said clause as it was not in public interest. Thereupon, the learned senior counsel submits that the notice inviting tender as on 19/5/2025 stipulated the period in the impugned clause being clause number so and so as last 5 years, but subsequent thereto, the same was reduced to 3 years in order to accommodate certain parties. The learned senior counsel further submitted that in spite of certain orders being passed in WPC number 5051 of the 2025, the respondent authorities have rejected the bid of the technical bid of the petitioner in terms with the impugned clause being clause number so and so, and on a totally arbitrary and on a totally non-applicable ground, that is clause 2.2.2.4,
2 minutes.
2.2.2.2,
2 financial thing, yes.
2.2.2.
Financial capacity under the.
Where is that?
101, Milord.
2.2.2.2. No, the way that the last 5 years it has to be given.
That is at 103, Milord.
2.2.2.2. And
102, sorry.
2.2. And you showed me the another
That was in the other writ petition, my lord.
no, that particular clause in
104.
this here,
104.
that where the latest can be given.
Yes, yes, 104, 2.2.2.72. 104.
On a ground which could not have been applied. That is clause 2.2.2.2.
7.
2.2. In view of
Ah.
clause 2.2.2.7 bracket 2.
Yes.
The learned senior counsel therefore submitted that the respondent authorities have left no stones unturned in order to render the whole evaluate the petitioner as technically not eligible so that it can be granted to the respondent number 3. Per contra, Mr. K. Gogoi submits that the clause, impugn clause, being clause number 2.2.2.4 bracket Roman 3 bracket Roman 2 bracket small bracket 2 is clear and specific, and the respondent being the author of the document, as per the settled principles of law, this court ought not to interfere with the said tender process. First, he further submitted that the petitioner did not submit the latest balance sheet, the final balance sheet,
Net worth.
net worth,
Net worth.
and resultantly, the respondents have also rejected the bid of the petitioner in terms with clause 2.2.2.2.
Lordship. And
First,
with
it is the opinion of the court.
Concern reading of Lordship, with the concern reading of page 97, Lordship.
Okay.
Page 97. 2.1.13, Lordship.
2.1.
1.13, Lordship. Even annexer TL, Lordship.
It is the opinion of this court that instead of passing any interim directions at this stage, it is the opinion of this court that taking into account that the respondent number 3 have already been issued a letter of acceptance, it would not be in the interest of justice to pass an interim order at this stage. It is also the opinion of this court that the writ petition requires, both the writ petitions require an early resolution. Accordingly, this court directs the respondent authorities, that is the respondent number 1 and 2, to bring on record their stand by filing their affidavits on or before 3rd of December 2025. Liberty given to the petitioner to file any reply thereagainst on or before 7th of December. The respondent number 3 is also given the liberty to file the affidavit on or before 4th of December. An attempt shall be made to dispose of the writ petition on the next date, both the writ petition, this as well as WPC number so and so on the next date. The records pertaining to the technical evaluation in respect to the present, in respect to the tender in question, be placed before the court on the next date.
Regarding the equity part, Lordship has said, my lord.
Oh, good so. Mr. Kane Chaudhary, the learned counsel, senior counsel appearing on behalf of the petitioner, has strenuously argued that there is a requirement for passing an interim directions in view of the fact that there is a likelihood that the respondent number 3 would enter into an agreement on or before 5th of December 2025, and thereby it would lead to creation of various equitable interests. Full stop. It is full stop. As stated above, this court is not inclined to issue any interim directions without giving an opportunity to the respondents to produce their instruction by way of an affidavit. Be that as it may, it is observed that non-granting of non-passing of any interim directions today shall not shall not create an equitable interest in favor of the respondent number 3.
Deeply.
For admission, I can.
Federation of Aya. What is this? So many affidavits filed. What is?
Item number 18 will also go, Milord.
Oh, item number 18 lists the matter on so and so. File your affidavit detailed, not these 2 pages affidavit. And see the video while preparing the affidavit. Yes, what is your case?
My lord, claim amount is in page, my lord, 36.
So many affidavits filed. Urgency, no urgency, what? Writ of quo warranto and mandamus to take necessary steps in accordance with the letter dated so and so. What is this letter?
It's a pending amount, my lord.
What pending amount? Oh, this matter.
Yes, ma'am.
Ah, you don't need to say. Both of you.
Yes, my lord.
He says he has paid the money. You say that you have paid the money.
My lord,
You have
my
not
lords.
paid. Yes. I forgot.
Not as per the, my lord, earlier order, my lord.
I've asked you to file affidavits, sir.
My lord, not we have filed the affidavit, my lord.
Whether to file an affidavit as regard the entitlement of the petitioner and also taking due note of the affidavit filed by respondent number 3. You are respondent number 3.
My lord.
I am representing.
You say that you have paid the money.
Yes, my lord.
And
The
what
amount has
do
been
they
paid.
say in, where is respondent number 1's affidavit?
As per number 1, there is no such department, my lord.
Okay, you are to file the affidavit.
Not I have filed affidavit, my lord, for as number.
Where is your affidavit?
It's in the record.
Understood. You are respondent number?
3, my lord.
You filed on 17/3.
17, my lord, as per the order, my lord.
17/3.
Yes, my lord.
No, you filed on 4/10. Who is respondent number 3?
My lord, I'm the respondent of 3, my lord.
No, no, no. You
But
can
3
be
is there, my
respondent
lord.
number 3.
I have 2, my lord.
Yes, you
Yes,
don't
I'm-
know for whom you are.
He is representing respondent number
Yes,
2.
you are 2, he's
Yes,
3.
3, my lord.
I'm
He and
3
four,
and
my lord.
4.
He has filed an affidavit on 4/10,
My lord,
wherein he says that he has paid the money to you.
my lord,
Now let us see your affidavit, which
Madam.
was filed on 17/11.
my lord.
Where is that?
It starts from page number 86,
Age?
86, my lord.
How much you are claiming, mister?
My lord, I am claiming, actually I am claiming in 41 lakhs. In the representation itself, my lord, page 49.
How much you are claiming? Mr. Counsel for the petitioner, have you read the affidavit filed by the respondent number 2 or not?
Yes, my,
Do you want to file a reply or not?
my lord.
If you don't file, you are in serious trouble.
My lord.
You want to file a reply or not?
I'll tell.
Fantastic. In pursuance to the order dated 31/10/2025, the respondent number 2 has filed an affidavit in opposition, wherein it has been mentioned that an amount of rupees 21,01,600 have been duly paid to the petitioner, and the remaining claim of the petitioner
Page 92. That are under option, my lord. 92. Top.
to the tune of rupees 41,46,600 have been disputed by the Bill Verification Committee. The petitioner, the counsel for the petitioner submits that the petitioner would like to file a reply to the said affidavit. This matter again on before vacation.
Not yet, my lord.
Okay. On 10th of December 2025, the affidavit in reply be filed on or before 4th of December.
Right.
Huh?
May I seek your lordship indulgence? Lordship, to mention a matter, one matter was mentioned today morning, unlisted, to be listed, and your lordship was pleased to list it today. The mentioning was by the respondents. We are caught unaware. I appear for the petitioner. My prayer is, let it come on Monday.
Which matter?
It's writ petition.
Oh, it was fixed today.
Yeah, it was fixed today.
It should come, it should come.
Lordship, we don't have the brief, and I have,
Oh, 2 o'clock, get a brief.
I have personal problem in the afternoon because
Oh, don't worry. If he has a good case, he'll get an order. If he doesn't, don't get an order. He'll get an order. Don't worry. Or you take the second brief.
no, Lordship, I have a doctor's appointment.
Madam, I'm telling you, ask somebody else to appear in that matter. But the fact remains out here, if the court had fixed the matter has to come. It is the registry's fault the matter did not come. For that, I'm not going to do that.
Lordship, the
We'll
registry.
no, no, madam, I'm not.
Lordship,
Timing item 10.
Yes, what are you challenging?
Basically, the petitioners were the contract laborers. They were engaged in the service of OITC. There is a settlement. That settlement was arrived at in the year 2012. The purport of the settlement is that the contractor may be changed, but the contract labor will not be changed. However, the contractor has committed some misconduct or attains the age of superannuation, then that will define it. Now, one of the clause when this settlement was arrived at was that the contract, if they have instituted any case or raised any industrial dispute, that should be withdrawn and thereafter they will get the benefits. Now, these contract laborers has filed to one case before this honorable court for their regulation. Because of this reason, they have been disengaged. Because of this reason, they have filed one case before this honorable court for their regularization only, so they have been disengaged.
They have been?
Disengaged.
When?
Initially disengaged in the month of June. Thereafter, they were also taken back, and they are subsequently, in the year on 1st September 2025, they have been disengaged.
Disengaged. Where is the disengagement?
Look, if your lordship,
Now what do you want here?
they should be engaged in terms of this settlement. But this settlement is still in operation.
There's a labor court, industrial tribunal judgment. What is this for?
Because at the relevant point of time, we raised the industrial dispute for fixation of our salary. But these dispute were resolved through a settlement, and that was an all India basis settlement. In that settlement, some incentive was given, offered to the contract laborers. They will get some fair wages and other benefits. And one of the condition is clause 1, there is the service security. Service security is that the contractor will change, but the contract laborer will not be changed. Of course, if they commit some sorts of misconduct or attain the age of superannuation, then they will not be engaged. Now, one thing that is, my lord, if your lordship come to page 87, sorry, yes, 86. Relevant page is 88.
Yes.
Clause 12, that was a circular issued from the head office to all concerned. The contractor shall not, clause 12, contractor shall not engage, employ or deploy any workman for ONGC contract execution who has raised any dispute or labor dispute, either personally or through a union, claiming regular employment or higher wages in ONGC. However, ONGC shall provide details of the workmen exempted from these provisions due the orders or direction from the labor authorities, industrial tribunal or courts. The contractor shall issue letter of appointment to each contract laborer before deployment, specifically all this. So we have filed a case before this honorable court. That is a read application. And that is the only reason.
So have you been engaged?
We have been working since.
No, shall not engage, employ or deploy any workmen for, means they have, this will happen in future. Engage, which will happen in future. Employ, which will happen in future, or deploy. So these are things which is going to happen post this notification. Now, therefore, you have not been disengaged. Whoever have been engaged already, it's a different aspect. This clause is only for.
Actually, what happened, we were working under a contractor. The terms of this tenure of this period of the contract has expired.
When?
The new contractor came in. Now, as per this settlement, if the new contractor comes, he will now page 43.
So your case, if I can get it rightly, is you have moved some industrial disputes. And because of the industrial dispute you have moved pertaining to fair wages,
Yes.
you apprehend that you would not be employed, engaged or deployed in view of clause 12. Therefore, you are against this revised fair wage policy. Isn't it your case? Okay. Let us issue notice to them. We'll see what can be done.
So the problem is that we have been disengaged. We are not into.
So it can't be a
Yeah.
case of disengagement.
Thought notice.
No, short notice, because you see, any interim order pass means granting the final relief today.
That is your last discussion.
Because tomorrow, if I have to dismiss your petition, then what will happen during this period?
That is the problem. There's some short notice mechanism.
Issue notice making it returnable on 15 December.
15 December.
Oh, you are not there.
The 15 December, so I have some problem. My son's marriage will be there.
Okay, when?
Let it be before 15 December.
10th,
All okay.
10 December. December. Mr. K. Gogoi accepts notice on behalf of the respondent number 3. As regards the respondent, extra copies of the petition be served upon him during the course of the day. As regards the respondent number 1 and 2, the petitioner is directed to take steps by way of speed post by Monday. In addition to that, liberty is given to the petitioner to effect service upon the respond number 1 and 2 by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioners here, the case of the petitioners herein is that they had for fair wages raised an industrial dispute which stood resolved on the basis of an award being passed on 25/9/2014 in reference case number 4/2009. The grievance of the petitioners herein is that on 28/7/2025, a revised fair wage policy have been made by the Executive Director, Chief Employees Relation of the ONGC, whereby amongst various clauses, one clause stipulates that a contractor shall not engage, employ, or deploy any workmen for ONGC contract execution who have raised any industrial or labor dispute, either personally or through union, claiming regular employment or higher wages in the ONGC. Mr. A. Dasgupta, the learned senior counsel appearing on behalf of the petitioner, submits that by this clause, in the revised fair wage policy dated 28/7/2025, a right which is being conferred under the Industrial Disputes Act 1947 to raise an industrial dispute have been curtailed, and those who have raised industrial dispute have been arbitrarily and unreasonably debarred from being engaged, employed, or deployed by the contractor. The learned senior counsel therefore submits that clause 12 of the revised fair wage policy dated 28/7/2025 is contrary to the settled principles of law, and more particularly, settled principles of law. The respondents are directed to bring on record their stand by filing their affidavits on or before 5th of December 2025.
Timing item 24.
You have that?
My lord.
See?
But the first document which is written in vernacular, my lord, that is my neighborhood certificate. The second document is the 100% actual certificate.
Not copy is not given. No copy is given.
Well, I'll sort.
No case.
These are of 2019 laws. These certificates are of 2019 laws.
Huh?
Certificates of 2019 laws.
So you say that it cannot be 2019.
Basically, these certificates are valid for 6 months or more.
Is it required to be given periodically?
And also,
Where is the rule?
also kindly have page 29.
Yes.
Lodge. The clause B, certificate of locality of the tender to the fishery concerned by the concerned circle officer mentioning the distance from the fishery concern. They have to specifically mention lawsuit, the distance. The distance has to be mentioned in the certificate lawsuit regarding the neighborhood certificate.
Certificate of the locality of the tenderer to, so it has been given that it is 3 kilometers.
Yes.
It is lawsuit, actually they are residing more than lawsuit 7 and 8 kilometers away from this site also.
But this is the certificate. Have you challenged this certificate?
Because we applied for other RTI lawsuit.
No,
but
Mr.
RTI
Mr. Counsel, rightly or wrongly,
Yes.
a certificate has been given.
We have lodged a complaint lawsuit. Since we know lawsuit personally that they are residing more than 7 and 8 kilometers, so we lodged our complaint. They have not responded our complaint yet. Second thing is that lawsuit, we have filed RTI application. Lawsuit will see the reply to the RTI application. They have objected to finding the copy. Had there been lawsuit?
No, have you lodged the complaint? Have you written to the circle officer that this certificate cannot happen?
It was not provided to us. We personally, we just specifically mentioned that they are residing in 7 and 8 kilometers away. And
No, here there is one person who has given that particular year, na? This is given by the circle officer on 21st of August 2025. He has looked into this complaint.
Yes.
This is the answer to the complaint. Page 68.
Pay certificate of pay 68 was there. Yes, this certificate was not provided to us.
Now you have the
Yes,
certificate.
now we have the copy.
So therefore nothing remains.
Kindly, on 69, lawsuit page 69, this is second representation. It was lodged on 27th of August. After lawsuit, kindly see the next page. We have been called for to record our statement at page 71. So till that lawsuit, probably the inquiry has not been conducted lawsuit. Because we have been called to appear on 20 of November.
So they have you have been asked to appear.
Yes.
So what is wrong?
So,
Go there.
before our appearance or before recording our statement, how the inquiry report can be given by the cycle officer?
Huh?
Before recording our allegation or statement, how the cycle officer can certify that this person is residing in this place?
Mr. Counsel, you have to understand first,
Yes.
you have raised the complaint initially before the circle officer.
Cycle officer.
The circle officer gives a report that is at page 68.
Yes.
68.
Yes.
Thereupon, you have submitted a representation before the district commissioner. Isn't it? That you require call for an fair investigation. And in pursuance thereto, they have already issued summons to you. In this investigation, which is being done by the district magistrate on 1310, 1311, you are asked to appear on 2011.
Yes.
Go there, fight it out. Thereafter, unhappy, I'm always here.
So that is what I'm saying, lawsuit.
So nothing remains now.
In the RTI reply lawsuit, in the RTI reply lawsuit, it was provided on 29th of October. In clause 3 and 4 lawsuit, it is stated that they have objected to furnish the copy of this application. So for timing lawsuit, may issue notice to the.
You do one thing, and once the investigation is done, and it is found that this person don't stay there, very well, they are out. You file another petition. I give you the liberty. You appear there.
They may give a specific observation to conclude their findings, lawsuit, inquiry and investigation within specific time. lawsuit.
Why?
Otherwise, they will time lawsuit.
No. You see, we can take it. Who is appearing for the other side? You. The district magistrate is you. Mr. Gogoi, do you have initiated some proceeding for complaint petition which they had filed? Now that proceedings culminated early, around 2-3 months. And thereupon, if you are aggrieved, do whatever it is. And if you get anything, if you get at something, I give you the liberty to challenge. And once they come up, yes, the certificate has been falsely given, then obviously they will also take action.
That observation, lawsuit. Which party to
Therefore, heard Mr. N.J. Gogoi. N.J. Gogoi. What is your name? Jay Kolita. Appearing on behalf of the petitioner, Mr. K. Gogoi appears on behalf of the District Commissioner, Sipsagar.
2 and 4.
Appears for the District Commissioner, Sipsagar, as well as the Circle Officer, Sipsagar, Revenue Circle. Ms. S. Sutia appears on behalf of the respondent number 1, 3, and 5.
For 7 also I am applying also.
And who is for 7?
I am applying 7.
7, na?
7.
I 7 who got it. 1, Kegogo appears for respondent number 2, 4, and 7. Yes, Tuti appears for respondent number 1, 3, and 5. Then you appear for respondent number
8, my lord.
8. Anybody else for this, the Eastern Register of Cooperative Society? Nowadays, we don't have cooperative. Oh, yes, Miss MD Bora appears for
So
respondent
up to
number
us,
6.
my lord.
Respondent number 6. The present petition was been filed by the petitioner challenging the work order dated 18/8/2025 issued by the Joint Secretary, Fishery Department, Government of Assam in favor of the respondent number 8 and further seeking direction upon the respondent authorities to issue a fresh work order in favor of the petitioner in connection with the settlement of the Brahmaputra Part 1, Min Mohol Sipsagar. The materials on record revealed that pursuant to a tender notice issued for settlement of the Brahmaputra Part 1 fishery dated 13/5/2025, on annual lease, various bidders participated in the said notice tender proceedings. It was found that upon evaluation made by the tender committee, it was found that out of the 7 bidders, 3 bidders were invalid due to non-submission of documents and the bids were not considered. 1 bidder withdrew his bid. Amongst the other 3 bidders, which included the petitioner, you were there, na? And the respondent numbers, who others were there?
I'll respond number 8.
8 and another one has to be there, na?
Yes.
Nutun Gotonga.
8 and 10.
Huh?
8 and 10.
8 and 10 remained in the fray. The respondent number 8 was found to have submitted the highest valid bid. And taking into account that the said respondent number 8 had submitted all relevant documents in terms with the NIT, and also taking into account the report of the Revenue Circle Officer, it was decided that the respondent number 8 should be granted should be set or be settled the fishery in question for a period of 7 years from the date of handing over of the possession of the fishery after completion of all required formalities. This order, dated 18/8/2025, has been put to challenge before the instant proceedings. It is the case of the petitioner that the respondent number 8 did not have a certificate, did not have the certificate valid, did not have a valid 100% fisherman certificate, as well as the neighborhood certificate. And as such, the settlements so made in favor of the respondent number 8 was illegal and accordingly sought for quashing of the order dated 18/8/2025. When the writ petition was moved, this court permitted the petitioner to bring on record by way of an additional affidavit certain information which the petitioner, counsel for the petitioner submitted that he had been able to get under the Right to Information Act 2005. From the additional affidavit which had been filed, it appears that the petitioner had raised certain complaint, had filed a complaint before the before the circle officer. Before whom did you file the complaint?
District Commissioner.
Huh?
District Commissioner. District Commissioner.
District Commissioner. No, prior to that.
Prior to circle officer.
Sir, before the circle officer, Sipsagar Revenue Circle. And in that regard, the circle officer, by the communication issued on 21/8/2025 to the additional district commissioner, submitted that both the respondent number 8 and 10 had submitted valid 100% fisherman certificate as well as Riverside Dwellers Certificate. The petitioner, being aggrieved thereupon, submitted a representation before, submitted a complaint to the district commissioner on 27/8/2025. To conduct an impartial investigation into the matter, as well as cancel the settlement made in favor of the respondent number 8. Further to that, the petitioner have also alleged that the certificate which was issued to the respondent number 8 was given without carrying out actual verification, and as such also sought for appropriate legal and departmental actions against the officials and the groups involved. This court further takes note of that pursuant to the said complaint being submitted on 27/8/2025 by the petitioner, the district magistrate Sipsagar have endorsed the file to the executive magistrate Sipsagar, who have issued for making necessary inquiries. And the said executive magistrate Sipsagar have issued notice to all notice oblique summons to all concerned. To make inquiry as regards as to whether there were any irregularities in the 7-year lease settlement of the Brahmaputra Fishery Part 1. It is also noticed that the next date has been fixed on 2011/2025. It is the opinion of this court that unless and until there is any inquiry, any document, any official document showing that the certificates which have been issued in favor of the respondent A to B made without proper verification, or such certificates are cancelled. This court cannot enter into the arena of facts as to whether all the members of the petitioner of the respondent number 8 are 100% fishermen, or as well as whether the respondent number 8 fishermen society, cooperative society, is within the distance as stated in the certificate so issued by the circle officer. This aspect is, however, being looked into by the executive magistrate Sipsagar. And as such, it is therefore the opinion of this court that as the said authority is looking into the said aspect, it would not be proper on the part of this court at this stage to proceed with the instant writ petition. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The executive magistrate Sipsagar, who is presently inquiring in respect to the complaint petition filed by the petitioner dated 27/8/2025, is directed to complete the said inquiry proceedings, preferably within 3 months. Full stop. Depending on the outcome of the said inquiry proceedings, the petitioner, if so aggrieved, would be at liberty to approach the appropriate authority, including this court.
One observation kindly, the certificate now Lordship is relying upon, this certificate doesn't bear any memo number.
Aha, argue there. I know you want, or do you want to, or you want to show this video there? That Mr. Rekul, no, further, nothing more. ইয়াতে এটা লিখি দিম হা। During the during the course of the hearing, Mr. So-and-so appearing on behalf of the respondent, number 8 have placed before this court 2 certificates which are kept on record and marked with the letter Y, X and Y.
Production list, motion item 2.
Where is he? Same order. Which package?
Number 2, my lord, it is package number 1, my lord.
Huh?
Package number 1, my lord. And
Same.
and 3, my lord, package number 2, my lord.
এই গোটেই কেইটা এই পেকেজ কেইটা চাই পেলাই অৰ্ডাৰটো আমাৰ শিৱানী আছে, শিৱানীক দি দিলেও আজি এটা মাৰিছে। Same date.
My lord.
Same.
For admission item 13.
Lordship, we file our affidavit.
Huh?
We file our affidavit, Lordship.
Affidavit filed. So nothing remains.
Lordship.
No. The petitioner heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Miss?
K. Borpujari on behalf of 8.
No on behalf. You can be only on behalf of ASTC. There is no on
Lordship,
behalf
Lordship.
of anybody else.
Lordship.
Appears on behalf of so-and-so, ASTC, and so-and-so appears for so-and-so and so-and-so. So the petitioner herein have challenged the letter number ASTC/CE/ISBT/GHY/2016/1066 dated 12/9/2024, issued by the Managing Director, Assam State Transport Corporation, whereby the respondent number 3 and 4 were allowed to run the toilet block gents and ladies close in western side of ISBT Betkuchi without any tender process, isn't it? Yes, Mr. Samua Khan. Hey, Samua Likhi.
I'm sorry, Millet.
It is seen that pursuant to notices being issued, an instruction was placed on 10/11/2025 before this court. Wherein, when it was brought to the attention of this court that the said renewal so granted in favor of the respondent number 3 or 4, 3 and 4, na?
3 and 4.
3 and 4. Was without any tender process, and this aspect having come to the notice of the Assam State Transport Corporation, thus steps were taken for cancellation of the said of the impugned order, and the said authority was also deciding to float tender in accordance with the prevailing rules and guidelines for operation of the toilet block and complete the tender process within 45 days from 31/10/2025. Taking into account the said submission being made on 10/11/2025, this court directed the Managing Director of the Assam State Transport Corporation to bring on record such stand by filing an affidavit on or before 19/11/2025. In terms with the said, an affidavit has been filed by the Managing Director of the Assam State Transport Corporation on 18/11/2025. In the said affidavit, more particularly at paragraph number 3, the submission which was made on 10/11/2025 have been duly incorporated. And it was also mentioned that by the order dated 7/11/2025, the impugned order have been cancelled and a fresh NIT has been issued through the GEM portal. So it was also mentioned that the auction process shall be finalized by 15th of December 2025. Paragraph 3 of the said affidavit, page 26, being relevant, is reproduced hereunder. So considering the above, as the impugned order has already been cancelled and steps have been taken for initiation steps have been taken to settle the toilet block in question by way of a tender process. Nothing further remains in the writ petition. Accordingly, the writ petition stands closed.
Obliged, Millet.
14.
Oh, this matter. Yes. So action has been taken. See, give it to you. This is what you asked. Recovery certificate, everything has been done. So your limited prayer in the writ petition has been answered. Isn't it?
Yes.
Now I think you need to go to the Bakizai courts. Go there. Okay, you see that, therefore I said, nah, last time you were asking for time, this order made everything,
Lordship.
remember?
Yes, 2910, your lordship detailed order is there.
Yes.
In fact,
This
last
order,
time-
therefore, further progress happened.
Manoj, on the last occasion on, this matter was listed before Justice Nair. My learned friend for the private respondent had submitted that they were willing to make the payment. On that ground, the matter was adjourned on that date. Now,
No, whether they make the payment, they don't make the payment, we are not concerned with that.
no difficult.
If they make the payment, do you have the check with you?
Your Lordship, I have my instructions over the last 1 week since the matter was last listed. My clients have tried to contact the petitioner as per the contact information which is given in his affidavit. But there has been no information, so if I may please request the learned counsel for the petitioner to share his contact details or even share my details with the petitioner, then we will coordinate efforts and settle all dues. We are most willing to make the payment.
You have to pay him with this amount.
Yes, Your Lordship.
No, let that attempt be made then. Let an attempt be made.
If I may please request,
Yes, today itself, I'll hand over all details, bank account,
and-
everything.
and I will share it with my.
We have it again on 3rd of December.
3rd of December.
By tomorrow or by Monday, Mr. Ganguly is going to provide you the bank details.
Because I'll provide today itself.
Okay, along with the up-to-date interest
Good.
on this
Good.
amount. And you make the payment in the meantime. Else this is going to go, because if it goes before the CGM, there will be criminal proceedings.
Yes.
We need to quash this. If you have any problem out there, no problem. Okay.
DNSS was it 461 warrant for levy of fine that.
Oh, yes, he comes up with this. Alright. So better off you ask your client to make the payment.
Yes, Your Lordship.
There might be some concession as regards Mr. Ganguly, some concession on the interest aspect, but if you may have something,
Sure.
negotiate and finish it off
Yes,
by
sir.
3rd. Because otherwise on the next date, nothing is going to happen. Okay. Yes, yes. Pursuant to the order passed by this court on 29/10/2025, this court, full stop, Mr. K. Gogoi, appearing on behalf of the respondent authorities, have placed before this court a set of instructions. The said instructions are cumulatively or collectively kept on record and marked with the letter X. From a perusal of the said instruction, it appears that the Assistant Labour Commissioner, Zone 3, Tezpur, Honitpur, have requested the learned Chief Judicial Magistrate, Honitpur, to initiate proceedings for recovery of the awarded amount of rupees 642,809.26, along with interest at the rate of 9% on the said amount from 2/5/2018 till realization. In addition to that, the recovery certificate have also been issued on 19/11/2025. Ms. So-and-so, who appears on behalf of the respondent, number 5, submits that the respondent number 5 would like to settle out this dispute by making the due payment to which the petitioner herein is entitled to. Taking into account the above, list this matter on, what is the date? I said 3rd, no? 3rd of December 2025. Mr. A. Ganguly, the learned counsel appearing on behalf of the petitioner, have already furnished during the course of the hearing the bank details of the petitioner.
I will do so right after the hearing, right now.
Good stop. The respondents, number 5, is given the liberty to make the payment to the petitioner, failing which, this court appropriate directions would be passed for further proceedings, in respect to the proceedings before the, for continuation of the proceedings before the learned chief judicial magistrate. Make the payment.
15.
Yes, what is your matter about?
Non-payment of outstanding bills, my lord, for
Your payment, this one.
relief materials. And the affidavit has already been filed.
Hmm.
And they understand that the verification is going on.
Hmm.
So, my lord, in this regard, your lordship has several petitions has been disposed of
Ah.
out of the same Indian order, my lord. This order is.
You don't know?
Okay.
So one order is good, twice more strong, or the three orders of the same judge given on the of the same date, it makes very strong. Is it something like that? Huh? How do you dispose could you?
Madam.
16.
Where is excise?
Just now they are waiting.
It's a dry day. Today I have not seen any PHE council also. Today I have not seen anybody. Chalo, let us ask the superintendent to be present because they have not taken the, who is to take the payment? Commissioner. Okay. We ask the Commissioner Excise Department to be present as none has appeared. None has appeared on behalf of the Excise Department on call. See? See? They're just waiting outside. They thought that I won't take it up.
I was looking.
Why are you not paying? Well, did you get their instructions
Yes,
or
madam,
not?
we have the instruction.
Are you going to pay that?
Madam, we would like to file an affidavit, madam.
Don't file
Something,
regarding what?
we have received some instruction. They are relying on some rules, madam.
What is the rule?
Rules say that since the rules do not mention about a refund, therefore.
Okay, let us now come on to section 31. Read it. If you cancel in terms of section 31, what happens? Isn't it?
Yes, but
Mr. Bhattakur? The unpaid, unused a portion has to be returned. Isn't it?
Even in a, yes, 31, even in a case of cancellation, but here.
Cancellation, here nothing, you have not issued the license or issue the license to him.
let us file an
Devoid
affidavit.
of
madam.
295 or 289, issue the license to him. You are going to issue. And say that it is an exception to 295 and 289, you are issuing the license to him. See, very well. And I won't take it as your instruction later on. Some of your senior colleagues may come up, Mr. Bhattakur shouldn't have said that.
That is why, my lord, let us file an affidavit in 10 days, my lord, we'll file it.
Interest has to run because he has given that option from that. From 111, interest is going to run.
Filed affidavit since last 1 year, my lord.
1 year. No, affidavit, no affidavit, nothing doing. But yeah,
And last
we-
day, my lord, they said that they agree, we're going to, but they.
awaiting a written communication pursuant to the order dated so and so.
We have received it, madam. We'll file.
What is the written communication?
Date 20 November, my lord.
What is that?
Instructions for the case, my lord. Here they are saying that since the amount was deposited pursuant to letter of acceptance for the bill issued, the same cannot be said to be mistaken collection and therefore is not entitled to refunds.
Chalo. You do one thing, you file an affidavit and I'll give you a time for reply also.
My lord.
File affidavit by Wednesday
Wednesday will.
and you file your reply by Friday
My lord.
and we have it next Tuesday at 2 and finish it.
My lord.
You take up the ground of interest.
Yes, my lord. Definitely, my lord. No, they stand is now, my lord, fluctuating. I'm surprised, my lord.
Now we'll have it on Wednesday,
My lord.
first this matter so that they can file the affidavit by Monday. Lekho, pursuant to the order passed by this court on 1/11/2025. On 17/11/2025, the Standing Counsel of the Excise Department, Mr. D. Gogoi, had submitted that he was awaiting a written communication pursuant to the order passed by this court on 1/11/2025. The Mr. I. Botagore, appearing on behalf of the Excise Department, today submits that on 20/11/2025, an instruction has been sent to him, wherein it has been mentioned that the petitioner is not entitled to the refund. In that regard, he further submits that an affidavit would be filed on or before November 28th, 2025. List the matter on December 1st, 2025. It is observed that if no affidavit is being filed, this court shall proceed with the disposal of the writ petition on the basis of the materials already available on record.
17.
What is this?
My lord, in this matter, affidavits have been filed, my lord. But my
What?
lord, due to
So fat matter, what is this so big
because
matter?
of a very personal urgency, my lord.
I have a long liquor license.
Lord, sir, they are
What do you
supposed
do
to
with
file
the
a reply. Your
MFL?
Lords.
Huh?
They are supposed to file a reply, Your Lordship, to my affidavit in opposition. They have taken time on last occasion.
They have not filed.
Lords,
Are they enjoying an interim order?
Lords.
My lord, may I kindly have this matter on Monday or Wednesday, my lord?
Why?
Because of personal urgency, I have to be at the airport at 4 o'clock, my lord, because of my bereavement.
You are to reach the airport
By
at
4
2 o'clock.
Cool.
2 is now 2:50.
I have to reach home and
No, your flight is at what?
5.
5 o'clock, okay.
Lordship, I will pray for taking up on Thursday or Lordship, next Thursday.
But Mr. Bottakor, I don't grant adjournments for senior counsels. I have to maintain my standard. He is a senior counsel. Why should I grant it? He has difficulties, his junior will argue.
Lordship, one aspect, Your Lordship, I am also not fully prepared since I
Okay.
was on Thursday.
None of the parties have urgency in the matter.
No, Your Lordship, urgency.
Accordingly, list the matter after matter stands adjourned, sine die to be listed only upon due applications filed jointly by both the parties.
Lordship, may kindly Monday, Your Lordship.
Have it on
Monday.
Absolutely no. Both of you are not ready to do the matter.
Lordship, since there is an order for Your Lordship.
He has seen that parties are not interested in an early disposal of.
Your Lordship may take it up today, Your Lordship. Your
List
Lordship
this
may take it,
matter
Your
up
Lordship
4
may take it up today, Your Lordship.
Interim order passed earlier shall continue.
Your Lordship may take it up today, Your Lordship. I will, Lords. Only, Lords.
Are you?
No, Your Lordship, Your Lordship.
You go. Ask your junior to argue.
Madam, may I kindly have it on Monday, madam?
No, they'll just go. Cost 10,000.
No, but it is.
People, these 10,000 will be distributed amongst all the lawyers who later on have difficulties, whose matter does not reach because of your matter. The 10,000 will be distributed.
Madam, Monday, madam. Monday or Wednesday, madam.
10,000 cost.
Monday or Wednesday, madam.
You are enjoying interim order. We vacate the interim order.
Madam, Monday or Monday only for a day. This is only for a day. I'm paying only for a day.
I'm not worried.
Only until Monday. Monday, my lord may hear the matter, sir.
Are you? What's your name? Miss So-and-so submits her senior is not available today. Accordingly, requested for an accommodation to list this matter again on 3rd of December, no, I forget. 3rd of December 2025. Interim order passed earlier shall continue being there.
Canadian fifth law, sir. Canadian fifth law.
Third will be your lordship. Fifth of month. Fifth, your lordship.
Fifth, I can't pick it up. I'm busy. It's 8.
Hey, obliged.
Lords.
Lords,
Eight.
lords. Obliged.
Deeply obliged.
19.
Yes,
May it
madam.
please your lordship, we have filed our affidavit. Lordship, I'd like to pray for some time to file a reply to that affidavit. Lordship, I have a simple prayer, my lord.
Oh, that matter.
Greenwood Metro, my lord.
Where you want to clean up the city and they want to pollute the city.
Yes,
Is
sir.
it something like
Lordship,
that?
what is the present state?
100% are not going to change the
Lord-
scenario in the city. There are 11 lakh vehicles flying in the road.
Lordship, may kindly have a look, page 125, para 13. I have a simple prayer, my lord. Paragraph 13, my lord.
125, para 13.
Para 13. What is the present status, my lord?
The subsequent RTI board and a deponent informed the vigilant that out of the 158 numbers of diesel operated city bus which are flying in route 2323.
4 numbers is already rerouted. Lordship, 4 number.
Based on that.
Lordship, the association is before my lord and already 4 has allocated their route and 32 have applied
No,
for
no,
you.
you see,
Lordship.
Mr. Mohanto
Lord.
has submitted, there is some non-compliance to something. Last time, if I'm not wrong.
No, Lordship, we are going to
The
issue.
necessary notification under the Motor Vehicles Act.
Lordship, we will issue notification. That's why I'm praying before my lord that pendency of the writ petition shall not be a bar to issue notices.
No, no.
Yes,
no.
this is my prayer. That's why I'm reflected prayer 13. Already some of them has rerouted. The association is before this lordship. Some bus owner has already rerouted their route.
No, they have also to leave, na? Livelihood is good.
Lordship,
So therefore, you want to issue a notification?
lordship, liberty may be, pendency may not be a bar, lordship.
You want to file a reply?
Yes, sir.
When?
Lordship, 2 weeks may be granted. 2 weeks may be granted, Lordship.
2 weeks
Yes, sir.
after vacation?
Sure.
Infructuous it would become.
Lordship, I have some difficulty in this matter. The signatory is not here.
Now, would it be infructuous if I
Yes,
have
sir.
it after
It would
vacation?
become infructuous. It would
2
probably.
weeks, okay. So can we have it on 12th of December?
No,
yes.
An affidavit in opposition has been filed by the respondent number 3 pursuant to the order passed by this court on 3/11/2025. The counsel for the petitioner seeks 2 weeks' time for filing the reply. The learned counsel also submits that there is urgency in the matter, taking into account that the policy would be effective with effect from the impugned actions would be effective
From 1st of
with
January.
effect from 1st of January 2026. Taking into account the above, list this matter on 12th of December 2026.
my lord, can it be on 15th of December, my lord?
Okay,
8 to 12
15th of
perhaps.
December 2026. Ms. M.D. Bora, submit. The learned standing counsel for the transport department submits that leave should be granted for the purpose of issuance of the such notification. It is the opinion of this court that the instant pen, that the pen, that the inst, that the power to issue notification is absolutely within the realm of the authority concerned. The issue involved in the instant proceeding do not relate to the question as to whether notification should be issued or not. Under such circumstances, the pendency of the instant petition shall not be a bar for issuance of notification if so permissible under law.
I'm so deeply obliged, Lordship.
Supplementary item 27.
Mr. Kaur Gogoi appearing on behalf submits some more time is required for obtaining insight as to whether the amount for claim has been admitted or not. What is your? So this is the amount, na proposal one and these two proposals. That is some 11 lakhs 54,472 and 2 lakhs 24,350.
My claim is 13 lakh, 13 lakh 78,000.
How much?
13 lakh 78,000.
That is what it is. So there are two amounts. 1154 and 224.
Lord.
Makes it 13 lakhs 78,000.
Lord.
That's your claim.
Yes.
Because our police case. Ali paragraph 6, 4, 5, 4 and 5. Four and 5, 2, it was instruction of Pokuri. Instruction is kept on record and marked with letter X. Police for 6 months from the date it is paid, given to the DGP. Yet Buddha had it. Make payment is entitled to make payment. Okay, to matter.
This is the status of the tender now. It is at the stage of technical bid, it's under consideration.
How much time?
The exact time, let it be after 4 weeks, madam, we'll try.
4 weeks, we'll have it.
Madam.
Give me some time so that we keep taking into account that it is said
Yes, madam.
that the
Priority.
process is being pursued with priority and it is expected
Yeah.
to be completed within a short period of time.
Madam.
So let's have it sometime in the first week of January.
Madam.
May I please, my lord, may I like to inform one thing?
Yes.
My lord, on the last occasion, that is 31st October, in the last hearing, they were supposed to provide explanation for the delay. In the meantime, my lord, on 7th of November, they have again, I would like to show my lord that document. They have again extended the bid extension. And my lord, if their conduct is to be seen, on 4 occasions, they have extended that without giving any explanation why this is being extended. And my lord, they are only relying on one clause of the tender, which is clause 5, which says that the original
You are
time
Mr.
period.
Srivastav.
My lord, may I just show one rule?
You are Mr. Srivastav.
Yes, my lord.
Mr. Srivastava, you see, when a tender is being issued, it is these people who are there.
Yes,
who
my lord.
want a particular thing, they are giving an offer. Against that offer, against the invitation for offers, you have given an offer.
Yes, my
Look here,
lord.
this is my proposal. Look here, I want to give you in these terms. They accept or they don't accept. Now, if the period has been extended and you don't want to participate, we can give you the liberty that you can shy away, and I don't think they will be taking up any course of action against you. Isn't it,
My,
Mr. Gogoi?
That we can, immediately we'll do that. In fact,
If
My
you
lord.
want to come out, you can very well come out.
my
I give
lord,
you the
I am
liberty.
just suggesting.
No. The thing is, you see, the problem arises. You should also acknowledge that the jurisdiction of this court is very limited in these matters.
Yes, my lord.
So now they say that they are taking it up on priority and would be completed. So I'm fixing it in the first week of January 2026 so that they can give an update to that effect, whether it has been completed or not. That's all.
My lord, can it be done before the winter vacation? Because all I am submitting is that even the Assam procurement rules under which they are seeking extension, that also only gives in case of exceptional circumstances, and it's already been one
Whether
year.
they have exceptional circumstances or not, you want to challenge that? You have challenged it. There is no exceptional
My
circumstances.
lord,
So
if
therefore,
you
do you want that the tender should be made null and void?
no, my lord, that I am not seeking.
Then don't come up with this. This is between you. No. Pursuant to the order passed by this court on 31/10/2025, Mr. B. Gogoi, the learned standing counsel of the NHM, have placed before this court an instruction issued by the Mission Director, National Health Mission, Assam. In the said instruction dated 7/11/2025, it has been mentioned that the tender process for operation and maintenance of Mitunjoy 108 ambulance service have been delayed and is taking time mainly due to detailed technical evaluation process, the need to examine representations and grievances received from some bidders, and the time involved in obtaining necessary government approvals. It is further mentioned that the process is being pursued with priority and it is expected to be completed within a short period of time. The said instruction is kept on record and marked with the letter X. Taking into account the above, list this matter on 7th of January 2026 for an update. Full stop. In the meantime, the respondents shall take effective steps so that the tender process could be completed.
Oblige, my lord.
Production list, admission item 1.
Again, renew the prayer for adjournment till Monday. They filed their affidavit in opposition.
Mr. Das, you have to also understand one thing. Interim order was till today. If I adjourn this matter, if I don't take up this matter, would the interim order be extended?
I'm deeply obliged for that. I'm deeply obliged.
So therefore, why was this hurry mentioning out there?
But you am deeply obliged.
Lordship, as per the order dated 9/10/2025, we have been directed to furnish in a seal cover.
Okay, this matter is connected with Mr. Bonik's matter.
Lordship, that
Which
has
they
been
withdrew
withdrawn.
yesterday.
Withdrawn day before yesterday.
Day before yesterday, they withdrew the matter. In
Ah.
fact, here there were 17 people. There 5 people had filed a case apart from me. Out of that, 4 have withdrawn.
Now what do you want?
Lordship, today it was fixed and basically, Lordship, we have been, the results has to be given in a seal cover before this court as per the order dated 9/10/2025, Lordship. So I have brought the seal cover, Lordship.
And Lordship, as per the tender document, at page 25, we have received the system generated email as being the H1.
Where is that order in seal cover?
That's
Lordship,
9/11.
9/10/2025.
Where is it? The court considering the fact the petitioner had a valid wage certificate on the last date of submission of the bid directs the respondent to allow the petitioner to participate in the auction which is demand. Shall be also allowed to carry out the inspection which shall be demand. Thereafter the petitioner shall be allowed to take part in the schedule. On completion of the auction, the results thereof shall not be declared without the further leave of the court. The council shall be placed before this court in a seal cover the rates received from the participating bidder in the auction process. Okay. Your only case is that you were held to be technically non-responsive because of that certificate.
Yes.
Now the court have already permitted you.
Yes.
So nothing further remains in the writ petition except the fact that if you have more or less, that is your thing. This is nothing remains here. In fact, this opening, I should not have done it. They should have done it because of the order I am doing it. You had a good case. You means Bonik had a good case. He has. He never told me. Okay, what is your name? Edifice. What is the contract for?
This is for the dismantling of the Kachar paper mill. Demolition, disposal.
There are many components. What?
Yes, auction.
No, because you see, I see one edifice engineering.
Yes.
One bid is
So
given.
total 4 were allowed to participate.
Huh?
Total 4. Three were technically qualified and 4, that is the petitioner has been allowed by virtue of this honorable court order.
No. Why there are so many bids there of the petitioner itself? Different bids. Why?
Lordship, that is the auction process
Process
online.
online.
Okay.
So one will bid, then again there will be other bidding, then it will be a continued. That's the.
Okay. Now, the best part is there are. Oh, the petitioner, you are the highest.
Yes,
You knew it.
because it's a system generated mail as per the tender document. only. Page 25 it's a system.
So nothing remains now.
Lordship, but technically they are not qualified because they have not
But
submitted.
you have not challenged that order. You see,
Lordship,
the
the order is
problem arises
dictated-
because of this order. That is why I'm saying the petitioner shall proceed to the site on so and care. Thereafter, the petitioner shall be allowed to take part. On completion of the result thereof shall not be declared without the leave of the court.
Only participation, Lordship, was allowed.
Okay. Now, if it is found that the petitioner herein is not qualified without the certificate, now how do I take care of paragraph 17? Tell me. Of that order. How do I take care of it? That is why I said you were there, na? That day when the matter came up of Mr. Boni, I said one thing, that how am I going to take care of this? Because in fact, the repetition was allowed on 9/10 without giving you an opportunity.
Wanted to, I need to participate and also.
Not only that, see paragraph 17. This court, considering that the fact that the petitioner had valid OS certificate on the last date of submission of its bid, directs the respondent authorities to allow the petitioner to participate in the auction process, which is scheduled on here. The petitioner shall also be allowed to carry out the inspection of the site and so and so. Now, whether the other bidders have been made party or not,
In this petition, no lordship.
then how, then if those bidders are not made a party, how can this court, because any order passed today would be going against the interest of the other bidders.
Lordship.
How do you take care of that situation?
Because we will not be aware of who were the bidders. And I was allowed to participate because here when the bidder is there, it's an auction process.
You knew, no, Mr. Das, you knew who were the persons who have submitted the bid. Technical bid is open, everybody.
So that I will not be able, that it's not open.
Technical bid was over. How did you know it was cancelled? You were held to be technically
I got an
non-responsive.
email. I got an email.
Is it not put out the portal?
Email to everybody, lordship.
Individually it goes.
Individually email to everybody.
Everybody it goes.
So it is not known who are the bidders.
No.
It will not be known at that point of time when they.
But in normally, who are the technical bidders? Do you mention who are the technical bidders? Competent
No.
after the process.
No, no.
We only intimated who were not qualified by the system generated emails. It was not put out who were qualified. They came to know by individually they are not qualified.
Is it done under GEM?
It is under MSTC.
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 MS.
It is done by the MSTC, I suppose.
Yes, lordship.
MSTC. MSTC does it. Because they will have a right to say who were the technical bidders. Don't you think so?
Also, even if they allow the technical evaluation stage, because that is also not set aside by this honorable court. Technical evaluation, they are not qualified. If the technical evaluation stands, they are out of the competition because the qualified will be, the next H2 will be allowed to get the work because he is the second highest bidder, also technically qualified.
Just for example, I hold that they are technically qualified.
Then they get it.
Would that not impact the number two?
Yes, but it will. They
So
should
how
have
is it possible?
that-
Have you filed your affidavit?
Yes, lordship.
In your affidavit, have you said who were the technically qualified bidders? Show me that.
My notes, yes, lordship.
But it was filed yesterday.
Page 132, lordship. Lordship, page 126.
Huh?
Page 126.
Where is the petitioner? What is the name? Edifice.
At fees, 5.
128.
Number 5, did not qualify as the ISO certification is expired before the auction or advertisement date, hence disqualified and no further evaluation has been made thereafter. Okay, so there is not looked into. Then how, then, because there are many others who have been here. Just for example, Prague India, disqualified as a party has not submitted OS certification and not provided any work experience certificate. So if Prague India, isn't it being affected if this court passes or not? Is his case Prague India?
No, SPS.
In their case, what had happened is that they had not submitted only.
But Mr. Bonik should have told me about this thing. No, he didn't say, my lord, I want to withdraw.
In
SPS still.
SPS. They did not submit.
Disqualified because OS certification not submitted and also the self-attest. You also did not submit.
Lordship. It was an inadvertent mistake.
Inadvertent mistake, you did not submit.
They had not given the certificate at all.
No, whether you have given or not, that is, they ask for that certificate, whether it is a mandatory requirement.
Lordship, and if Lordship.
You have gone into the concept of historical document.
Lordship.
Now, historical document comes under Rule 2315 of the Assam Procurement Rules. But that would it be applicable for AIDC? Tell me.
No, Lordship. now this document which was given, now again, they will be bound by this tender document. Now
Ah.
tender document, they have in page 45,
Ah.
what is the effect of this is a pre-qualification criteria.
Ah.
They themselves have mandated that if they find that there is some kind of a document is not genuine or whatever we to the respect, they will look into it. So they will ask for verification. So what they could have done is that in that scenario, others did not come. I had come. They could have just asked me whether you have the certificate. Lordship may just peruse my certificate for a moment.
This covers the entire.
If my certificate is just perused, just to show. Page 80. Sorry, page 79.
Why is nobody else coming for taking up it? Nobody seems to be serious. Others? Lehok. Heard Mr. Ajay Das, the learned counsel appearing on behalf of the petitioner. Mr.
Ekakoti,
Ekakoti appears on behalf of the AIDC.
AIDC Lordship.
And Mr. Bukiel appears
2
on
and
behalf
3
of the
Lordship.
government.
Appear on behalf of 2 and 3, AIDC.
2 and 3. He appears for 1. So pursuant to the order passed by this court dated 9/10/2025, the Mr. Ekakoti, the learned counsel appearing on behalf of the respondent numbers 2 and 3 have placed before this court the seal cover of the rates received from the participating bidders in the auction process. Full stop. The same have been perused. Full stop. And returned to Mr. Ekakoti to be produced again on the next date. Full stop. This court have also taken note of the affidavit in opposition filed by the respondent number 2 and 3, wherein the minutes of the meeting dated 24/9/2025 have been enclosed. From the said minutes of the meeting, it is seen that out of 20 bidders, only 3 bidders were found to be qualified for participation in the auction bid. The petitioner herein was also held to be not responsive. Be that as it may, by virtue of the order passed by this court on 9/10/2025, the petitioner was allowed to participate in the auction process. A question duly arises as to whether the entire technical evaluations were carried out, whereby various bidders have been disqualified on the ground of non-submission of a certain document, which this court permitted subsequently to one of the bidder. The technical evaluation carried out on 24/9/2025 can be said to be in conformity with the provisions of Article 14 of the Constitution. It is also seen that in the present proceedings, the otherwise qualified bidders have also not been made parties. Considering the above, let's this matter again on 10th of December 2025. There shall be no allotment of the contract to any person, any entity till the next date.
Lordship, may kindly proceed on 12th December. 12th December.
12th I'll be out of, 12 Lordship I'll be out
Because
of.
10 I will be at Kohima, Lordship.
12th I'll be out of session. 10th is convenient. Please.
Lordship,
Eighth.
he'll be there. He'll be there.
8th of December.
Lordship, and direction for the addresses of these people, because if they have to be made a party, where will I get the address? I don't know these people individually. It only says the name of the.
Mr. Egolta, no?
Kakoti.
Ekakoti, appearing on behalf of the respondent number 2 and 3 shall provide the addresses of both the qualified as well as the disqualified bidders to Mr. RJ Das by Wednesday, Wednesday next?
Wednesday, Lordship.
By date
Or
to
Tuesday
date.
also.
Huh?
Obliged.
For orders item 21.
We are having it on 12th, huh? 15th, or 8th, 10th, 10th,
Lordship, 8.
10th, 10th.
10.
Yes, Lordship.
In the meantime, you file application.
May I please, Your Lordship. Let us take for provide the schedule as to how and when the amount payable to the petitioner would be disbursed, Lordship.
Well, there is subsequent development, my lord. In the meantime, the petitioner has been, the respondent has been transferred out, my lord. And the same time, my lord, on yesterday, an order has been passed, my lord. I'm handing over that particular order. my lord.
For what? Transfer.
My transfer order is of 10th November, my lord. They have immediate his post and
What order has been
order
passed?
that the amount has been, a certain amount has been paid, my lord. That is the final amount and no amount will be released, my lord. Because the initial, the amount, the fix of the rate of the tenth is in the higher side. my lord. This is yesterday's order, my lord.
So you have already got, see, 7,14,181.
Yes, Lordship.
Your claim is how much? 10 crores.
10 crore 96 lakhs, 14,000.
So they have passed this order. So rightly or wrongly, you have to challenge this order. We have to drop the contempt.
Lordship, actually, what happened, Lordship?
No.
No.
Mr. Counsel, without the challenge, this nothing.
Lordship, already they have filed their affidavit, they admit the amount, I'll come to the business 72, Lordship, in their affidavit, Lordship. Amount payable to the.
You are asking for which order? Compliance to which order?
Look, we'll find in page number 35 of the complaint, contempt petition, my lord.
Are you saying that this is the order for which there was a direction to pay as per Tamser Ali
Yes, Lord.
after carrying out verification?
Yes, Lord.
You claim 10 lakhs, 10 crores,
So,
they paid 7
Seven.
already, and you want more than that.
Yes.
Go to the civil court or challenge this order.
Lordship, in the writ petition, they have not disputed, Lordship, amount. They admit the amount, Lordship. They file the affidavit, Lordship. We have entered the affidavit with contempt petition, Lordship. They not denied, Lordship. There is no dispute, Lordship. And subsequently, they have filed the affidavit in contempt petition also.
That they are
They
admitting
admitted
10
the amount,
crores.
Lordship.
10 crores, you have admitted.
Ten crores, 96,000 can come to 72.
No. Prove it.
Admitted lordship, in affidavit.
No, I am dropping it. No, nothing doing. Your name?
The subsequent proceeding lordship.
Absolutely, by way of this contempt, you cannot enlarge. This is what is happening by way of contempt. We are looking into this. We can't. Contempt, we have to look into it, whether it has been complied or not. You could not have got this money amount if it is not even in the chronological list. It should have been paid chronologically because this is the direction.
What is that is also PWD department.
What is your name?
Jay Ahmed lordship.
J.U. Ahmed, the learned counsel appearing on behalf of the petitioner. Mr. S. Bora appears on behalf of the respondent number 1. Huh?
Newly implemented.
Respondent number 2. The instant application of proceedings have been filed.
Court order also lordship. They have not taken the court order also lordship.
The instant proceedings have been filed alleging willful and deliberate violation to the order passed by this court dated 24/11/2021, passed in WPC number 2950/2021. Full stop. A perusal of the order dated 24/11/2021 reveals that there were specific directions issued to the Principal Secretary BTC to make necessary inquiries and upon verification, if it is found that the petitioner is entitled to any amount, the same be released in accordance with the judgment of the full bench in the case of Tamser Ali and others versus State of Assam and others reported in 2008, 4 GLT, page 1. Full stop. It is being, Mr. Espora appearing on behalf of the respondent number 2 have placed before this court an order dated 20/11/2025. The said order is kept on record and marked with the letter X. From a perusal of the said order, it is seen that though the petitioner had made a claim of rupees 10 crores 96 lakhs 14,448, the respondents have already paid an amount of rupees 7 crores 14 lakhs 18,171. It is further mentioned that no further payment the petitioner is entitled to. So considering the above, the said order, which have been kept on record as per and marked with the letter X, is in the opinion of this court compliance to the order dated 24/11/2025. Passed 24/11/2021, passed in WPC number 2950/2021. Accordingly, the instant order, the present contempt proceeding stands dropped. It is, however, observed before parting with the record, this court, however, observed that a closing of the dropping of the instant contempt proceeding shall not prejudice the petitioner to assail the order dated 20/11/2025, if so advised. In addition to that, the petitioner would also be at liberty to approach the civil court, if permissible under law, claiming the remaining amount. So,
Lordship, at least one
It's
of them
advised.
is reflected lordship. They admitted and 10% will disburse. That may be already reflected lordship. By way of affidavit lordship.
take all these things. I'm not going.
After review.
These are cases, nothing to be done. Because you see, the contempt jurisdiction is very specific. You are to comply, you don't comply, take action. Nothing more than that.
This is partly compliant lordship. That is fine. lordship.
Partly, fully complied. You got more money. Yes, what is this next?
Lordship, although contempt, lordship order was to make payment within 3 months, my lord. It was not done in terms of Tamsher Ali, so we preferred one review application 264/2025.
How can you file review?
Because in terms of Tamsher Ali, my lord.
Samsar Ali, how is it applicable?
It
for
was, my
BTC?
lord.
How? Show me.
Oh,
How
they-
Tamsar Ali is
Yes,
Tamsar Ali
They
applicable?
have adopted certain guidelines in terms of Tamsher Ali. BTC authorities follow Tamsher Ali, my lord.
How do you know?
Yes, my lord, I have got communication to that effect.
The review is here.
Review petition 264/2025.
Okay.
Lordship,
List this
I
matter.
should submit one thing. Notice has not been issued.
Where?
No, in the review application.
Don't worry, we'll bring that review and dismiss the review and then
No,
we'll give
no.
him the money.
Lordship, review not before Honorable Michael Zotan Kumar.
Okay, don't worry. We.
No, no, I
we
should,
direct-
convey
don't worry, we
something, my
direct
lord.
this matter to be listed with that.
No, no, lordship, may I submit?
Lordship, file review.
Maybe go in your favor, just a minute, just.
Just a minute.
Wait.
Let me try.
Lordship, before issuing notice, honorable court observe at least you pay 10 lakhs of rupees, Lordship, before today. No, it is under active consideration. Only few days be given, my lord, because
How much?
Lordship, 1 week.
Okay. List the matter again on 10th of December 2025. Taking into account the submission made by Ms. Bibhuya appearing on behalf of the respondent, number,
Akash, Deep, my lord.
respond number 1. That an amount of rupees 10 lakhs is going to be paid to the petitioner.
It's under
And,
file has
it
been
is under
processed.
active consideration to be paid to the petitioner for an update.
23.
Obliged.
What is this? Orders or is it give? Admission orders.
Okay.
Orders एक कागज पर नहीं थे? मैं तो कहीं seriously I took Louis. Review petition. What is wrong with my order? My order.
May it please your lordship.
What is it?
Lord-
What have I done?
Lordship may kindly come to Lawzima Court's order dated 6/8/2025.
No. Why is the review?
Basically, there are two grounds. I would like to draw lordship's attention to page 21. Letter dated 3/4/2017. The respondent had contended that the letter was rejected. I would like to state that the letter was not rejected, it was only a resubmission. So there arises no question of us challenging the letter.
Have I issued notice in this matter? Okay, DK Mishra. Senior counsel, there is an application seeking review. First ground is that the term loan of rupees 600 was sanctioned on so and so and so. You have filed your reply?
Yes, we have filed it.
Everybody is represented?
Yes,
Huh?
I'm for 2 to 5.
You are appearing for 2 to 5? Okay, who is for 1?
One is Union, Your Honor.
Union, okay. Okay. Okay, you are appearing for 2 to 5. So service is complete. So we'll take up for disposal
Yes.
next date. Okay.
Lordship, can it be on 11?
What?
Can it be on 11th, Lordship?
11th of?
December.
Why? 11th of December. No, absolutely no. These are tiny matters. 10th of December.
Obliged.
List the matter on taking into account that the service is complete. List the matter on 10th of December 2025 for final disposal.
29.
দেখুন গো, কাগজখন নাই দিয়া। What is this? Not inclined to pass an interim order. What is this service? এখন নাই আহা নেকি? কাগজ বনোৱা নাই নি? কৰিছে? No affidavit regarding, you have not served by Dusty.
We have served it and we have filed the affidavit today.
When?
Affidavit Today.
Yes, any instruction, madam?
Lordship, the this constitution of this one, chairman market committee has been changed. New person has not been appointed. So he is the one, the chairman market committee is to like give instruction to the, as per instruction is from BTC. Lordship, I may be given some time.
This is again on that same.
Yes, yes,
bench
it is, my lord.
have
They have
already
arri-
passed an order.
They have approached lately. So they have approached lately, so lordship on the last occasion.
But that doesn't mean that you are not going to obtain instruction. They
Yes.
have it on next Wednesday. We finish it off. This
Will
type of
be
matters
fine.
cannot, because after all, you are losing.
Yes.
A person who have quoted a higher
Yes, yes,
amount, you have
yes.
not
Lordship,
given, you have
true.
given it to some lower person and he has not appeared.
My
But Mr. Counsel, why on earth you have filed the affidavit of service today? Okay, it has been submitted that the affidavit of service have been filed today. To list this matter again on
Friday, my lord.
28/11/2025, the registry shall bring on record the said affidavit of service. In the meantime, the respondent, BTC, shall also obtain the necessary instructions without fail.
Lordship.